So we're now going to move to item number 22, the telepsychology regulation discussion. Dr. Erickson.
Thank you, Dr. Phillips. We spoke about telepsychology at our last board meeting and also at our last 3 weeks ago, and then at the in-person board meeting before that. As a refresher for those that may be listening in, or for any of us here as to where we are with telepsychology and looking at a few issues historically. In 2011, the state legislature asked our board if legislative or regulatory changes needed to be addressed regarding telehealth or online practice. In its report back to the legislature, the board said that it was researching and analyzing the use of telehealth for the practice. 5 years later, 2016, the board committed to the following in its report to the state legislature. We said that we would develop telepsychology regulations that will instruct licensees how to provide telehealth to Californians, giving psychologists additional opportunities to provide care to underserved populations. So the Telepsychology Committee has held 4 meetings in which it discussed draft regulatory language for the board to consider. Included in our materials today is draft language that aims to accomplish the guidelines for licensed California psychologists to provide telehealth to clients and patients of their services. And the committee, I'm currently the chair of the committee, would ask for, and Dr. Phillips is on the committee, would ask for a motion to accept the language as written and begin the rulemaking process. I suspect that we want to have some board discussion and then see if there's public comment and then see if somewhere in there we're going to have a motion. God bless. Maybe first, trying to remember what I do as a committee person as opposed to, so ask for any board member discussion of the proposed draft for regulations.
I know that we put a number of hours into the consideration of these regulations or the proposed regulation, and it is reflective of a lot of consideration of things, including what other mental health service boards have done, what other legislative boards have done. We've looked at APA and other guidelines with regard to telehealth to make sure that to the extent possible we could be inclusive and specific enough to give some form of guidance to our licensees. Obviously, we can't make the language so specific that it becomes impossible for us to be for the licensees to adapt to the need for consumer services, or so specific that we omit to provide appropriate guidance to our licensees. So I feel very positive about the language that we finally came to after many, many drafts. But I know that there may be other people that have other considerations they want to take into account.
Mm-hmm. Dr. Hort?
Yeah, I have a question I want to ask you. First of all, thank you. I mean, I know it's been a lot of hard work, and I think these really look good. And my question is, this is about telehealth. We grant a generic license. So will these not pertain to people who are licensed psychologists but are not practicing telehealth? They may be organizational consultants. They might be, working with businesses or, things, It would be individuals in those, but still, they have a different kind of scope.
So substituting health, it could be telepsychology service or consulting. You're wondering if these would apply to that.
Yes.
I don't definitively know, but I think the answer is generally yes.
Actually, I have a different impression, which is
Please,
think
yeah.
that the original legislation that gave us the authority to pass these regulations were related specifically to telehealth and telemedicine and not to telepsychology in general, but I could be wrong. That's just my recollection of what the statutory language that allowed us to create a regulation.
Well, while we're looking it up, I think it's an important question and maybe not easily answered because we're sort of brushing up against that area of psychological consultation to an organization, a business maybe in another state. It might be done by telephone. Normally, we don't think of that as telepsychology. Some of the people don't have licenses that do that, and they're organizational psychologists, and some do. We're looking for some reference here on what may or may not be included. Ms. Marks?
Well, I think what this board has jurisdiction over is the practice of psychology and those people who are licensed or are engaged in activities for which licensure is required. So if licensure is not required, I don't know that the board has any jurisdiction.
I guess the question I have, Ms. Marks, was the statute that by which we, on the basis of which we promulgated this regulation about telehealth, or was it about telepsychology in general?
If you can give me a minute to take a closer look at that, because I don't think we've considered this question before, so I will do that.
And this
So
is-
I'm sorry, I
amongst
didn't mean to
yourselves.
put a kink in it, but I do think that it's something to, yeah, to think about and maybe explain in our regulations if we decide that. And, organizational and consulting are part of our licensure, our Practice Act, so
And
these are behaviors that people should be licensed for.
And Ms. Marks said when licensure is required, I often wish that I had a precise definition in my mind of when it is and is not required, and I don't. Ms. Jones?
I want to offer another thought, but I know we're still looking at that, so I don't want to distract.
That's fine.
Okay.
'Cause
Yep.
But I'm just reminded, number, I guess it's B4, about competency related to the provision of those type of, how, the delivery of services. I just was wondering, had the committee looked at it? 'Cause I think about the earlier presentation from ASPPB about the fact that in terms of the way they're doing theirs, not that we need to duplicate or mirror it necessarily, but there is that in order to practice in that manner, there's a requirement about continuing ed, or is it continuing professional development in that area? Did you all as a committee discuss that, or how would we be able to determine if someone is competent in that delivery?
Well, I've got 2 or 3 responses, and then I think probably Dr. Phillips does too. I don't know that we looked at that specific question. Hearing what we did this morning from ASPPB was informative, and I think probably a good idea, but we didn't consider that. And how we address competency now would be in the same way we do in any other area, whether it's neuropsych or a special kind of psychological treatment. We get a specialty expert to come in and take a look at whether it meets the standard of care.
And typically, in order to determine whether somebody's competent to work in a particular area, it's dependent on a variety of factors, which include education in the area of the delivery of psychological services through telehealth. It would require perhaps supervised experience with doing telehealth, and then it would require continuing to maintain your competency relative to it. So I think it's the same as any question of competency, but I understand whether, I
Yeah.
think the question you're asking is,
It's a
should
good
we
one.
be having a specific requirement?
Yeah.
About number of hours of training, or?
I guess the question also goes to, like, how you've laid it out makes sense to me. Is there a population of folks that would be that expert to be called in? You know, I mean, I just think in terms of, gosh, when I first joined the board, there was so much discussion about best practices and everything. I didn't get the sense that there was a large group of folks doing it. So when we're talking about leaning on an expert to then advise on, and maybe it's changed and someone's got a better sense of the population that does that services, that would be expert, that could help us.
I think we may be making too much out of this. I mean, I think somebody, if we want them to, they could say, under penalty of perjury, I'm competent to do this, I've had training, I've used it, I've da-da-da-da-da. You know, if we want them to, I mean, I think in that regard, it's just like any other area. We should be only working in areas where we're competent, and that would include if we offer telepsychological or telehealth services, we would be competent in the delivery of the services via technology as well. But I don't think I have to attest anywhere that I'm competent in clinical or this kind of clinical or
I guess
something. So, you know, but if we want that extra thing, I think people could attest to it. It's not like we're going to have a group of experts.
I don't mean to go ahead.
No, I
determine.
appreciate that kind
Yeah.
of distinction, but I guess the way I'm seeing it is slightly different, because I don't think it's an issue of making too big of something or thinking that people don't. I guess the question, or what resonated from me from the presentation this morning was the fact that there was a process in place to ensure people were doing it the right way. So when I'm thinking about protection of consumers, you know, I think we were talking about this yesterday about who uses Twitter, who doesn't use whatever the mode is. I don't think it's an issue about necessarily attesting. It's more so ensuring that people have those skills. That's what I took away from the presentation this morning.
May I just jump in here and just say a few things? One of the things, I don't think we're making much to do about anything. I think we need to get ahead of this technology. And this is one way that we are getting ahead of it, what you all are doing right now, coupled with, as you said, Ms. Jones, what we heard this morning. To cull some of that from what has already been done or is being done, or what they're doing right now. And this could certainly assist in, like you said, either under penalty of perjury or a test or however we get at that to help to develop that standard that we're going.
Yeah, let me explain, because I didn't mean that you're making too much. I think I was reacting to what you said, Dr. Erickson, which is a panel of experts, and to me, that seemed like, wait, we don't need to go.
Did I say a panel? I didn't mean to say.
Or an expert, you know,
Subject,
can tell us,
matter
subject
expert.
to expert.
No, I didn't. No. I
Yeah,
didn't.
so that's kind of what I was saying. It's like, wait.
No, I know what you were saying. So I'm saying getting ahead of it now, while and so that's where I was going.
Well, I actually think, and I appreciate what you have to say, Ms. Akwebadu. I think we're way behind. I've been seeing patients either as a psychological assistant or as a psychologist since 1995, if you count my practicum year. I was doing telehealth almost immediately, because we would have situations in which, for instance, someone would break a leg and not be able to come in for their appointment, but still need their appointment. Eventually, in the process, I began to incorporate video technology that I found to be appropriately confidential and was HIPAA compliant. I did that under the supervision of, initially as a psychological assistant, I did it under the supervision of a psychologist that was already using those services. I have psychological assistants now, and they from time to time will do telehealth, and I will aid them in understanding the process, understanding the limitations of the process, how to approach the process, what technology to use, and we will discuss how well the client is reacting to the use of telehealth. So I think there is competence that already exists in the field, which initially probably developed on the fly more than anything else.
But that's exactly what I'm saying. And I don't mean to cut you off, but you hit the nail on the head, because that level of expertise does already exist. So having that conversation with what we heard this morning, coupled with, like you said, you've already I'm sure you all have already been doing this, and sometimes people just don't know. And how do you codify this and standardize this? And that, the experts are here in the room, are they not? So,
I mean, I would estimate during any given week, probably, my practice is probably somewhere between 20 and 40% telehealth.
That's bigger than I
It
would have
is.
thought, yeah, that's good.
So then I guess I have a question then, and this is helpful, because I think when I took away from this morning, is there a lot of continuing professional development regarding the provision of telehealth and telepsychology? And again, you know, in terms of that, I mean, and kind of, I know it's kind of hard to go back, we can't really respond to that earlier presentation, but in terms of that kind of a requirement, is that something that you would see helpful, having been doing this for 21 years?
I'm increasingly seeing, and I saw Dr. Winkelman shaking her head yes in the background also. I'm seeing increasingly professional presentations on the appropriate use of telehealth, and even within particular therapeutic modalities. So I think at the recent CPA convention, there was a presentation on the use of telehealth within a more psychoanalytic frame. So I think more and more there's more literature and more education available for these purposes. And I know that in graduate programs that I'm involved in, we're starting to talk more and more to the students about telehealth and how they would appropriately use telehealth. Because the reality is, with or without the regulations, telehealth already exists within the field of psychology. So in that sense, I feel like we're kind of catching up after the fact, but that is sometimes the nature of the regulatory process.
So can I ask a question? These would be regulations, right?
Yes.
Okay.
More comment from board members before we ask for public comment? Ms. Jones?
Well, one other thing I would just add to that, and again, great conversation. I'm thinking about C, about the issue of unprofessional conduct. It sounds like then, much like we currently do when we look at disciplinary cases, if there is a violation of ethics, there's usually a referral to ethics courses, right? Or everyone's got to take ethics typically, right? In terms of condition of probation. It seems like if there was a violation of this, there would be that direction to the continuing professional education that you're just referring, or professional development that you're referring to.
There would be classes that would be available to people in order to be able to better acquaint themselves with the appropriate use of the technology. Because there is a lot of professional judgment involved in whether it's appropriate to use with any particular patient based on a variety of circumstances which we've attempted to enumerate here. So it works for some people, it doesn't work for other people. Some people do better in telehealth than they do in your office.
So I guess my
It's
point
true.
is, I guess my bigger point is that while I know that we had an update that some of our guidelines have already moved past, but it seems like should we move forward with something like this, we might need to look at how we look at disciplinary regulations and you know, just tied to, because I think that, as you just mentioned, the nature of the work and the specificity regarding the kind of unprofessional conduct might need to be more specified in what we have.
Ms. Jones, I think, if I understand, you're really suggesting that we think about this in a way that we operationalize what we're proposing, that if there's problems later, how are we going to make sense out of it, and what are we going to recommend, and do we have things that we would require of somebody that maybe would be put on probation? And I think those are all excellent things. Am I following what you're thinking?
Absolutely, yes. It's like basically how would we hold ourselves to be able to implement this?
Yeah.
Operationalize is the exact right word.
So having the public talk is fine. I just don't want to forget my question that I'm thinking Ms.
Whether this
Marks is
applies
still
to,
looking at.
let's
Yeah.
say, industrial, for purpose of discussion, industrial consulting
Right.
across state lines, or out of state.
Well, this is about within the state, isn't it?
It's telehealth versus teleforensics versus
Correct.
consultation versus right?
Well, telepsychology would be my word for all psychology, psychologists in California, but this is about telehealth, and so that's my question.
So if they have a license and they're providing service from a distance to a client, which is considered the originating site, would these regulations apply? If they become
If the client
regulations?
is not, if we're not talking mental health.
Right.
We're not talking health. I mean, I guess we can talk about healthy organizations and healthy workplaces and,
Let's say it was
stuff like
team
that,
building consultation by telephone from one part of the state to another part of the state. Would these apply?
That's my question.
So that's an excellent question. That's an excellent question.
By my hesitation, you can tell I don't know the answer
Well,
specifically. Yeah.
but I
That's what
think
they're-
Ms.
Yeah.
Marks is looking that up, and that's, because I think we may have to clarify this
But
in our
Dr. Horn,
regulations.
let me just say, that question coupled with, and you raise another point, a bigger question, I think, which is valuable, and which, is that where you were going also, Ms. Jones, about the bigger picture question as well? As we're developing this, or as you all are developing this, you want to look at, Dr. Horn said, but you also want to look at a bigger picture about discipline, coupled with not just in the state doing that. So I think the task is much larger.
Maybe, yes.
That's what I'm seeing, so.
And I think I'd have to answer the question, as I understand it, to, yes, this would apply to all licensed psychologists who are practicing the psychology under their license, whether or not it is considered direct mental health or not. Because because 2904.5 of the B&P code says a psychologist licensed under this chapter is a licentiate for purposes of Section 805, and thus is a healthcare provider subject to the provisions of 2290.5, which is the telehealth section. So I think it does not differentiate what that licensed psychologist is doing. So a licensed psychologist practicing as a psychologist would be subject to the regulations.
Would be called a healthcare provider regardless of whether they're providing healthcare.
If they're practicing psychology and they're engaged in those activities for which licensure is required, I would say yes.
Maybe you're suggesting we have the wrong term here, that it might have been better telepsychology?
Well, I don't know that we can call it telepsychology if there's a statute.
Are you talking about the proposed title of the regulation? Or you're, I think, being a little even broader than that, Dr. Horn, in questioning whether or not, if the regulations are being promulgated pursuant to 2290, which refers to telehealth, whether or not it is functionally related to those people providing health services. It does talk about telehealth, and still the psychology licensing law says that a psychologist licensed pursuant to that chapter is a healthcare provider. So I think that would mean that person is subject to the regs that are being promulgated pursuant to 2290.5.
And I guess in reading 2290.5, when it defines telehealth and it says the meaning, telehealth means the mode of delivering healthcare services and public health by information and communication technologies to facilitate the diagnosis, consultation, treatment, education, care management, and self-management of a patient's health care while the patient is at the originating site and the healthcare provider is at a distant site. That to me suggests something different, that it's really just talking about the healthcare aspect of of psychology as opposed to the other broader functions we take on as psychologists.
Well, that's what I read.
That's the way I read it.
That's the way I read it too, and then,
Dr. Horn, can you think of an example where this would be difficult for someone or some group? I'm wondering, to be practicing organizational psych under a telehealth regulation?
No, I haven't actually thought about it in that way. I don't think so. I mean, I just think this is written very healthcare-y, and so that's why I was asking.
Well,
And, you know, but I don't know. I haven't read it with that eye yet, you know.
Well, I think with that interpretation, if we were going to say that telehealth included all of any kind of telepsychological services, that that these regulations would not be sufficient to that purpose, in that we've focused so much on the healthcare
The
aspect
healthcare
of it,
aspect,
that we haven't thought about what other variables you'd have to consider if you're doing consultative services or something like that. I don't believe that's necessary, because I don't believe that's the intention. I think this was created for, I know that all psychologists are healthcare providers as defined, but I don't think all of us as healthcare providers are necessarily providing healthcare services.
Yes, that's right.
And in the sense that I would believe that the legislature meant it, so.
So does that lead the board members to think about whether or not these would be too restrictive to apply to a psychologist, a licensed psychologist who is providing something other than health services? That there's a reason why this shouldn't apply? I think at one point, the language was changed to refer to patient or client to encompass
So,
that non-health field, but I'm wondering if for some reason a licensed psychologist in a non-mental health field would have a problem complying with these regulations, and whether or not the board wants to think about pursuing some kinds of either a clarification legislation if it's necessary, or re-looking at the regulations.
Actually, I just reread the regulations very quickly. I think someone that's practicing outside of traditional telepsychology, where you would be talking to a patient or patients on the phone or on
outside of
video.
health.
Out
health
of a
part, yeah,
healthcare
yeah.
setting, like a specific
Traditional,
mental
yeah.
health care setting.
Right.
I think these still would provide adequate guidance to people in terms of
One
data
concern,
security and all those types of things.
one concern that I am aware of is that I think they're crafted with HIPAA in mind. And I think organizational people don't think HIPAA when they do team building by telephone from one site to another. Working with managers to plan or develop a team, for example.
But when we talked about HIPAA here, we just talked about all other relevant regulations and laws. So if HIPAA was not applicable to a particular situation because it did not involve protected health information,
Yeah,
then that regulation and law would not need to be considered by that person.
good.
There might be some other law that applies to people that do organizational psychology that relates to confidentiality that they would have to consider, but I don't think we're so specific here that it makes it necessary for us to kind of reinvent the wheel.
I agree. I think we can, as the need develops, if it does later, we can amend things in the years ahead.
I agree too. It is written very narrowly, and but I don't think in a quick read that it would constrain someone who's not doing traditional health, but does. And a lot of people who do consulting or IO stuff in particular use technology to do that, to deliver those services.
Mm-hmm.
And I think our focus is definitely traditional healthcare, but I don't think from reading it quickly that it would restrict those folks, but so.
It's a
but
good point,
it is,
though.
it's just something to,
And
think about.
I think if we made this into a rule, as a rulemaking breaking package, is that what it's called? Rulemaking package? If we made it into a rulemaking package, we could encourage people
Comment.
from other areas of psychology to look at them to see if in any way they feel like they would be impeded by any of the language here and make appropriate adjustments to it. My concern here is licensees and registrants have been asking for guidance on this subject for a very long time, and we have labored very hard at trying to provide that to them and waiting for appropriate guidelines to come out. And I honestly don't want to see this process slowed down any more than it has been already. I would rather get public comment as to things that we may have overlooked and then make appropriate changes as we go.
I think that's a good
But
idea.
I think that'd be one way for us to move forward, to start to give people some sense of guidance. And as we further perfect the regulation, maybe we'll have to take into account some factors we didn't consider, but that is the purpose of public comment.
Great, I agree. Ms. Jones, I think, was first. and then-
Okay.
So I have a question, because I'm reading this quickly, and I guess I'll say two things, and then I'll be quiet. Because your example of the patient who's broke their leg, this doesn't cover them. It says it's somebody who's temporarily located outside of the state, correct? So we're not talking about services within the state. Well, when I read through this, it says to render services to a patient who is a resident of California who's temporarily located outside of the state. So I just wanted to get clarification around that one. And then two, I agree for the sake of moving forward expediency. Just curious in terms of the last committee meeting, what are you all hearing from the public regarding what they're saying? Because in terms of the committee meeting, because it's not just feedback through the rulemaking package, but I'm sure that we're getting comments at the committee level, right?
Well, the committee is always comprised of two people. We wanted to move relatively fluidly in terms of being able to get things done, and the composition of the committee kept changing. Dr. Erickson came on, I came off, Andy went off, Fiva came on. So we have not had the same opportunity, I think, to get input from some of the stakeholders groups. But in response to your first question, the subsection A say a licensee is permitted to provide psychological services via telehealth to an originating site in the state, which means we can provide, the originating site refers to where the client is located. So if my client lives in the Hollywood Hills.
Well, read after to render services to, because that would be where the,
And.
It says
but that's
and. Okay,
Oh, that's
okay.
an and, so it's not only that.
okay, that's a clarification. Well, I will just say, I think that we need to scrap this way of doing two-member committees, because that would be what a loss to not have public comment. And I really think that we should do this through all of our committees then, because I think that we're missing a huge opportunity to get feedback. And I know we want to move fast, but that would not be, I think, our responsibility as a state commission.
I just want to make sure that everyone knows that even if the work is done in a two-person committee that's not noticed, that there is absolutely a time for a public committee at the time of the board meeting. So just to make sure everyone's clear.
No, I do, but I would say, Ms. Marks, when that was the response of why we wanted to do it, to move fast, I think that should never be our intention. And I know we had to do this for sunset review, but that seems a little troubling to me, because I know that we said we've been working on this for a number of years, but wow, what a missed opportunity, because we've had an experience where people felt like they hadn't gotten heard until the end with other things, that I think that as a standard operation of practice, we should never create a two-person committee solely to move something fast through the process. So that's my response to it. I know that we do report back, but yikes, I think we should not be operating that way.
Ms. Jones?
And I'm just, from a staff perspective, I think it's a matter of being able to have, getting some of the clarifying questions in the laws and in the regulations answered by legal counsel and staff with a subcommittee to be able to ferret out that information and then present a vetted, so to speak, package to the board. We also have the same setup with our enforcement committee, which is a member, two-person subcommittee that reports to the board. And I'm just saying this from a staff perspective, it's a preference of staff to sometimes ask some difficult questions of board or committee members that we want to ferret out before having a full board meeting, where then the full discussion can happen. I know we've been going through disciplinary guidelines, for example, and having staff have access just to a couple of committee members or board members and not having outside interest to participate in that has been a very valuable exercise for staff, and I'm hopeful it's been the same experience for the board members as well.
And again, I will just stand by that. I just feel like if I were a public member hearing that as a response, that would not sit well with me. And I think that I feel like nothing should be ferreted out. This is public, and I think that we've got to ensure that we have public communication at all times. We've dealt through a lot of tough issues in this board format, and that I definitely feel like I will say that I don't think we should do that. If that's the reasoning that we're doing something to get something just quickly through, I think this is part of the messiness of public participation. And I would just say, I don't think I realized that was our intention. I knew that we were moving quickly, as former President Erickson shared with us about the Sunset Review Committee. But I just feel like for common practice, I would just say I don't feel comfortable with that. And I think that we also should think about that. That's our reasoning. I don't know if that's the way we should go, because we have been working on telepsychology for 2 years. I don't think that helped us go any faster. It
Okay.
sounds like it may have prevented us from actually noticing meetings and getting public comment.
This sounds like a separate agenda item to me, so I would like to ask that this be agendized for us for the November board meeting.
That would be
So we
fine.
can have a fuller discussion of it.
That would be fine. Thank you
Okay.
very much.
May I just, thank you. I was just going to go back to where we are. And what I just wanted to say quickly, we know some of the limitations of this right now. So my contention is, that, as I had said earlier, is it some way, and I know we want to get to this and move forward so we can look at it differently and all of that. But as we do, I'm just saying to the committee, can we look at some of this in a broader sense so that we can be inclusive before we move it forward? The things that we know are problematic, can we get at those things now before we even move it forward? That's where I was going with that. And one of the things I'm thinking about in particular, and I'll be done, we know that with technology and all of this, that this is not going to stay in one state, it's going to move. And so I'm saying, how do we capture that? That was my comment. to the
And
committee.
Dr. Erickson may agree or disagree with me. I believe we took that into account in how we drafted these regulations.
Okay.
And I don't see, in reading the regulations and having been involved in drafting the regulations, that these in any way provide any limitations to people in other areas of psychology, but I'm certainly would look forward to hearing any public comment that would indicate that perhaps there was something that we overlooked.
And specifically toward that, I wanted to ask Dr. Horn if you thought it was more appropriate both for the practice of psychology and what is contained in the telehealth statute, for example, to indicate that these standards applied to those licensees engaging in psychotherapy, which is sort of separately defined in the practice of psychology, if that's what you were getting at. 2903 defines a practice of psychology and has a rather broad definition, but then specifically says psychotherapy within the meaning of the chapter means, and then it defines psychotherapy. If you were indicating that potentially these regulations might fit more specifically toward people practicing psychotherapy and were not necessarily needed to be applicable to those providing other psychological services.
Well, this for sure would fit psychotherapy or the delivery of psychotherapeutic services. So probably my answer would be yes. I mean, this is kind of a quick answer if I think about it, because I know there are other things, but I think that's really what these look to me like they're intended to focus on. Those kind of service, that kind of service delivery.
Right, so then the question is, as you read them, is the board intending it to, does it need to have these apply to the other psychological services outside of psychotherapy? So I would ask the board, as you talk about that, to consider that question.
Thank you, Ms. Mark.
That's correct.
And I have one more comment, Dr. Erickson, before we open it to public comment, I guess, too.
Well, no, I've got some comments too, but you go first.
I was going to say that I do think, while I agree with agendizing on a different meeting to talk about our practice, I do think, I mean, it's kind of what you said, Ms. Akwebudu, about ensuring that we have some kind of input before we move forward. It sounds like I think the committee needs to go back and have a fully noticed meeting to be able to have it. We have public members here who might have comments, who might not have comments, but I don't think we provided a sufficient opportunity to get those kind of comments before we move forward to kind of even consider a recommendation for a rulemaking package.
Is there a problem with doing it in this venue before the board? Because it's, I mean, the board meeting is where public comment is received, so now if you have a draft,
I guess where my concern is, Ms. Marks, I feel like in licensing committee, where we have spent a lot of time and provided people with the opportunity to have multiple two-day meetings where people have been able to give comments and give feedback and provide different scenarios. It sounds like we did not do this on this process, and it seems like we did it intentionally in some regard to move it faster. I think that that would be not the spirit in which I would think we'd want to work, and I think that we would probably want to go back and do a fully noticed type of opportunity. Here we can have people, because actually this wasn't posted, this was a hand carry item, so no one would have come to this meeting. I mean, unless the people are in this room know and want to comment, people that might have wanted to comment on this are not in the room because they didn't have this draft to review. So I would just say that would be my concern, and again, not wanting to impede the progress in the movement, but I think we, and from what I'm hearing, intentionally didn't open it up and have people have that opportunity to be able to give the feedback. So I'm concerned about that.
Before you spoke, I was going to offer that I agreed with your earlier comments that this is an important issue, and I don't know that we could get it decided today, but I wanted to lend my support in public to your raising the question. I know there's been a balancing of trying to get things done, public support and so forth. So I wasn't expecting to reopen the conversation, but I was looking for a time to quickly say that I valued your input, even though we didn't get it decided. Given what you've just said, perhaps, and I'm going to also check with our president, perhaps we can get the public discussion going now and get a sense in the next few minutes whether we have enough input and can make a few changes, or whether, no, we need to go back and have a lengthier meeting that's open to the public. Would that work with people?
I think it's a very practical suggestion, Dr. Erickson. I will say that we did have the benefit in this particular area of an enormous number of guidelines and other documents that have been drafted that suggested how telepsychology should be appropriately be addressed through APA. I believe ASPPB was involved in helping draft guidelines. I think there ended up being one joint set of guidelines and one separate set of guidelines. I don't want people to think that we just kind of made this out of whole cloth or didn't consider issues that had been raised by a variety of different stakeholder groups in the context of coming up with these regulations. So I don't think it was done with the intention of in any way preventing the public from having an opportunity to comment. I do know that when we have committees that are less than 2 people, if I understand correctly, Ms. Marks.
Or less than 3.
Less than 3 people, excuse me, that the public comment can occur in the board meeting as opposed to necessarily happening at a committee meeting. So there's still opportunity for public comment, but there may also be a feeling among the public that they've not had sufficient opportunity to review the regulations in order to feel comfortable that they're fully ready to make those comments. So I'd be curious to hear what the public has to say.
May I just say, going back to what Ms. Sorik said about the enforcement committee, if we could model it somewhat after that, because the public is, I'm on that committee as well, and that has worked out well, I think. And so if somehow understanding that we don't, that committees, one or two persons are on it, but it may be modeling it after that somehow could help based on, it's only two persons on the committee, making sure that somehow the public or someone is there represented. Because like what Ms. Sorik described about the enforcement committee, and it does move along quite nicely.
But I think what Ms. Jones is addressing is not our board, the public members on our board, but the public.
I know that as well. But we've been able to get, and could you kind of flesh that out for us a little bit? How do we get, because we do get comment.
Do that, though?
Yeah.
Maybe this is not the time to do that.
I think we're again going off, we're going off the agenda, so.
But that's a conversation that maybe we want to have and combine that together. But you're right on. It's beyond just the public members here, but it's the public.
I
And
just
somehow
want
we
to,
get those comments.
oh, I'm sorry,
No,
Mr.
I
Prater,
was-
are you finished?
No,
Okay.
I know.
I just want to respond to Dr. Phillips, and yes, the Open Meetings Act does specify that a committee of less than 3 people does not have to be noticed, and my understanding was that it's not so much the speed with which this can happen, because it hasn't been particularly speedy, but the speed with which you can
Score
get,
one for Nicole.
yeah, can get
That's
people
right.
together. My understanding is it just allows the board to be a little more facile in getting input from board meeting members who say, oh, as it turns out, I'm available tomorrow from 2 to 4 or something like that.
And I know that we're going to have an agendized item, but I definitely just want to say that I definitely don't agree that it's been speedy. I was really responding to how it was answered in the question of why we had a 2-member. And that is what we said it was the case, to make it go quicker. As we open up to public comment, it would be interesting, too, for me to hear how the public is responding to this conversation about the need to be able to go back to committee or whatever, because I do think that it would be important to hear that piece. And like I say, I definitely know that we are full of integrity as a part of our whatever, but when we answer the question and that's the response to make it go faster, that was my response to that, because I feel like that was what you responded to me. That's how the question got answered.
And maybe that was a poor choice of words, but we did want to try to be, as counsel said, be more facile in the way that we reacted to this, and to be able to do things more, just be able to schedule meetings more quickly, as we're well aware, sitting on this board, sometimes scheduling a meeting is a couple-week process. So when we have a smaller committee, we do have the opportunity. I don't think it prevents the public from having comment one way or the other. I will restrict whatever public comment is invited to these regulations, and as to whether people feel they had sufficient opportunity to input these regulations, there will be a subsequent conversation at another board meeting as to the propriety of having 2 or 3 person committees.
Good, I think that's.
As well as the spirit by which we do it, about facile and what that means, I think should be a part of that agendized item.
Well, yeah, I think that's implicit.
So I think we're ready, perhaps for public comment. Yes, please.
Melody Schaefer, Division 2. Just a few beginning comments is telepsychology, and I'm going to call it telepsychology because medicine is calling it telemed. I think we need to own our profession, which we seem to have a problem doing, in my humble opinion. Telepsychology has been going on for decades. I was doing telepsychology in the 1970s, gang, People ran hotlines. Our students are running hotlines, talk therapy. And if we're going to start legislating down to the description that you have here of trying to tell the psychologists that they have to decide in a certain way whether someone is appropriate for telepsychology, I think then you need to look at bibliotherapy and group psychotherapy and start legislating all of that. And that to me would be ridiculous and not within the tenor of, or the spirit of what other disciplines are doing in their approach to telemedicine and such. I really think we're missing the point here. I think the issue is truly around the technology, the appropriate use of it for the protection of the information that the patient is serving. Because this is a bit of, as someone said earlier today, the Wild West show. When you text a patient, how do you import that in a way or download it in a way that you can put it in the chart so you have documentation? If you email, is it encrypted? Is it secure? These are the things that I believe need to be spoken about. And I do believe also that you need verbiage that addresses in-state and out-of-state and make them separate. Otherwise, it's confusing our constituency, psychologists, I think, if you don't. Also, even some of the vernacular that you have here in terms of, you can see a client who's a resident of California who is temporarily located out of the state. Temporarily can be defined in any such way, yet you're talking about failure to comply with the regulations. These need to be operationalized if there is going to be some kind of retribution based on some kind of evaluation of what that means. But I really think if you go to telemedicine, that's been going on for years now, and we are like the last to get on the bandwagon. Companies are built. CNN talked about the MFTs, and companies are nationwide doing this. And I've been coming to these board meetings for about 10 years. And I think it's been more than 2 years, actually, that this has been going on, because I remember bringing from Carol Fallender something she wrote about 3 or 4 years that we joked at a Division II meeting of, did they ever look at it? So I'm happy to help. I'm sure there's many people that would be happy to help in any way possible. And I do think you are correct in what you said earlier. I think it would be not probably the best approach to take to not include a lot of people in at least putting it out there on email to all the psychological associations within the regional psychological associations and such, and other groups, to get some feedback so that whatever, just from a group dynamic perspective, so that whatever you finalize in your document, you will have already gotten the reaction to, and it will reduce the noise, so to speak, so you can move this forward. But I think, in my humble estimation, again, this needs to get going, and however you can. Thanks for letting me blather on here about
And if I could respond for just 1 second.
Sure.
And that is, telehealth was the word that was chosen for us by the legislature. That was not our choice of words, so we would have been
Did we
happy to.
push back
We would have
on
been
that?
happy to call, well, we could go try to get a legislative change, and then we're going to have telehealth regulations in another
It
3 or
may
4
seem, it may
years.
seem like a small thing, but at a time when our profession is being chipped away at by scope creep from other disciplines and from other groups that are very strong in adhering to standing up for their school, raising their flag, such as the AMA and telemedicine, then if not us, then who? And if not now on this issue, then when?
And I would also like to address the question of the Board of Medicine.
Yes.
They do not have regulations yet. They've developed,
Telemedicine actually does in some states, absolutely.
not in this state, they don't.
Maybe not in this state. But California is also a bellwether state for a lot of issues in mental health, as we know.
There's another
So what-
question, there's another question you addressed, I just wanted to
Yeah.
address
So
quickly.
what we do here may have influence for our field at large.
We can regulate what a California psychologist does within the state of California in terms of the practice of psychology. We can regulate what a California psychologist does with a California resident who's out of state, who is a resident of the state of California. We cannot regulate what a California psychologist does with a New York resident purely on their own, independent of their license, they're subject to the licensing laws of another state.
Absolutely.
So there's a limitation. I just
Yes.
want you to understand there's a limitation.
No, I
in the
already knew all
scope
that,
of-
but thanks for
scope of
taking
what
me
we
to
could
school,
do.
but I already took that course, yes.
Okay.
Absolutely, that's the case. Hence why our colleagues this morning were bringing up the ASPPB approach to that.
Right.
However, having a separate document that says something to that effect, because out in the field, this is, I know you all talk to many people, so I'm not telling you anything you don't know. People are talking about this all the time, of setting up shop without any direction, even if you have something that suggests if you plan on doing telepsychology or whatever you're going to call it, with patients that do not reside within state and are outside of state, it is incumbent upon you to contact that state, et cetera, et cetera, et cetera, et cetera, because it's saying something, but certainly at this juncture, you can't legislate what will happen, correct? And to keep that as a separate section as opposed to the within state and the within state patients that are now, for whatever period of time that will be identified, are temporarily out of state but are a resident of California, so that it's separated.
They are separated, but there's one as to which we may have no authority. The interjurisdictional practice with out-of-state residents by California psychologists
Yes, Stephen,
does not fall.
Dr. Phillips, I know. You already said that, and I said, yes, I understand.
I
that
thought you were
completely.
suggesting we should be creating a second.
Not at
regulation.
all.
Okay.
A
I'm sorry,
section,
I
because
misunderstood.
you will have calls from people that will say, well, I have a patient that's not a resident of California. If you put, I don't know if you wouldn't call a disclaimer, but some kind of, and Ms. Marks would know best what you would probably need to call it, something that would address the issue, that this is not under the jurisdiction. However, it is incumbent upon you as a licensed professional to decide otherwise. Otherwise, you're going to have a lot of people that will misinterpret what you're writing as being able to be projected on out-of-state patients. So the more clarity, the better. But thank you so much, and I hope you take some of this into consideration. Yes.
Well received. I appreciate your comments. I think we all do, and
And I would just want to say, because I know that Dr. Phillips said he wanted to answer really quickly. I think that your comment about telepsychology is one that I think we should consider. And so I think that's one response to it, but I don't know, we're not going to take all these questions and talk about it as a group, I'm assuming. But I just think that it's important that the questions that we're hearing, and this is why public comment is so important, allows us to consider something, because it might be well worth, as you mentioned, it's going to take about whatever years. It
Yes.
might be worth it if we hear from people that it is. So
Thank you.
I just want, it's important to say that the comments are not being, we have to discuss it as a board. And I don't think that I would, if your comments make a compelling argument for me to,
Thank
let's
you.
think about
Thank
this.
you.
And I think we need to do that.
And Ms. Jones, at national level, the APA and at the state level and CPA and all over, we talk about how we do not know how to market what psychologists are so that the consumer truly knows the difference between our profession and other ones. So when I'm training interns and postdocs, I tell them, do not identify yourself as a therapist or a psychotherapist, you're a psychologist. So here is an opportunity, and I understand we may all have different perspectives on it, and I like that let 1,000 flowers bloom thing. I'm one of those people, so I'm big on it. So maybe that's something that we can hearken to. And if it's impossible because it's going to take the state 10 years to let us change the vernacular, then of course you may have to
Or we
stick
could
with
pass
us.
the regulation and try for the legislative change at a later point.
Yes,
May I
yes.
just,
But I think it is important that we get.
may I just say one?
yep. We need to get more public, but go ahead.
Yeah, just one thing. Thank you so much.
You're welcome.
And if we start the conversation, then we can control the direction.
That's right.
Thank you.
That's right.
Thank you.
As
So if
opposed
we
to
start it,
what we in our
yes.
field have unfortunately over the years ended up starting to do in the other
So
direction.
let's go broad, because
Yes.
then, and as you said, right to, and then we can control that direction.
Yes, absolutely. Thank you for understanding the tenor of my,
We have another person, maybe several more, that are going to provide public comment, which is appreciated.
Dr. Jo Linder Crow is CPA. I want to make some kind of global comments, and I know that Dr. Winkelman has some specific feedback about the language in the regulations that you have put forward. Just to your invitation, Ms. Jones, to comment on the discussion you've had. I've been at CPA now for, I've forgotten, 12 years, something like that. So I've been through several iterations of how the Board of Psychology works, and it took me a while to become familiar with the fact that the Board of Psychology works in a certain way and has certain restrictions about the way that you have to work. I understand that you're not as flexible as we can be at CPA because you're bound by certain rules and regulations of how a regulatory body works. And so through the history of the board, when you used to have committee meetings during the board meetings, then you moved to separate committee meetings, we have adapted as you've gone along. So now that you have separate committee meetings, I have adjusted my schedule so that I attend many more meetings every year related to the Board of Psychology than I ever have needed to in the past. But that's okay, that's part of my job, and so I do that. I think and hope that by attending those committee meetings, we have actually served as a resource to the board by providing public comment at that time that I think actually ends up making things more efficient, because things can be fine-tuned and revised and modified so that by the time it gets to the full board, then maybe it's in a little bit better condition for a full discussion before it even goes out to public comment. So to your question, Dr. Phillips, about whether or not in this situation I feel that we had ample opportunity to comment, I would say no. Because we have an obligation as a major stakeholder in the work of the board to provide comment. So we will provide that comment, whether it's at a committee meeting or whether it's here, we will provide the comment. The danger here is that sometimes if you're running short on time, you're running low, then you sometimes want to limit public comment, which I always, as you know, find a bit difficult. But in this particular case, we weren't aware of the committee meeting. We didn't have a chance to provide comment. This is such a critical issue, and I will say that we're one of the ones who's been pushing, begging for these guidelines for sure. On the other hand, putting something out that is confusing for public comment, that is not as clear as it could be. Perhaps we have all learned our lesson about what happens when that happens. And so I understand the dilemma of wanting to move quickly and get things done. But I would have to say in this particular instance, we did not have opportunity. Now, I'm in a way okay with that because we're here today. And now is the time that we will provide public comment. However, I've also heard the kind of preference that we have comment, but then let's move ahead. Let's get it done. Let's put it out. So to me, this sort of serves as the place maybe that a committee meeting, the discussion that might have happened at a committee meeting, so that today it would be, you would be able to move forward. And I think to your point, Ms. Jones, we may be in a place now that we're providing the comment today that we could have provided at a committee meeting level, and then that might have actually made it possible to move forward.
I
So-
just wanted to
Yes.
mention one thing, Dr. Linda Crow, and that is CPA has been aware of that we've been working on these telepsychology regulations for
Yes.
a while, I believe.
Yes, absolutely.
And those materials were included in the May board meeting.
And we provided comment at the, when would it have been? The meeting you recently had in Sacramento?
Of the July meeting?
Right. We were there. I was there. Dr. Winkelman was on the phone. We provided comment at that time. I don't see that any of our comments were reflected in the final version of this, which is the board, of course, your prerogative, you can take or leave public comment. But yes, we have been there at every opportunity that there was to provide comment.
And
So-
I wanted to say, the reason we want to facilitate this process in the way that we did is not because we want to fool the stakeholders.
Oh,
into
no,
something.
I
It is
do not
because-
think that.
It is because we feel like we've been laboring with this issue for such an extended period of time without giving adequate guidance to our licensees, that we're trying to be responsive, and perhaps we were overzealous in our efforts to be responsive to the detriment of getting sufficient public comment.
I think you could probably argue it either way. As I said, here we are
Right.
today, and we are able to provide comment, and we will do that because you will allow us to do that. It's just that dynamic tension between wanting to move quickly and wanting to move with a document that, before it goes out to the public for public comment, is as clear and concise and provides as much direction as possible. I'm going to leave the other comments to Dr. Winkelman because they're more substantive when it comes with regard to the actual language of the document. But I do appreciate the conversation. And I think the board has the board obviously has the right to operate in any way that the board sees as appropriate in terms of the committee work and so forth. So I'm not questioning necessarily the way that you went about this. I'm just responding to your question about how it might look. And as I said, again, we're able to provide comment, I guess, in a way, just because I run an organization and I look at how organizations work. The question of how to do that the most effectively and efficiently is maybe up for discussion. So I appreciate the fact that you raised that question, because we, obviously, as you know, and I think that we have demonstrated that we want to be as much of a resource to the board and provide that perspective of how things look and how it might be read by your licensees, because we have some experience with how things, how important it is to be as clear as possible when you write a document like this, because we have been waiting a long time.
And echoing Ms. Jones' comments, as a result of this discussion, I do feel we could have done a better job of reaching out to stakeholders earlier in the process to get whatever feedback we could.
I agree.
So I appreciate that, and thank you for.
I don't think we did it with any bad intention.
Of course not, and I don't think we think that either.
And I want to say, I appreciate Dr. Phillips being able to respond about the we. I think the we is not a clear we on this, because I don't think I realized that was our intent. So I think that's also what we're having, which we'll agendize for the November meeting. I appreciate explaining it and almost justifying our kind of work, but that is, I don't think that that's a statement on how the whole board feels, because like I said, I'm actually a little bit surprised that we hadn't been noticing people. So I don't know if that we is for we as the full board, because that is possibly, that's the reason that I'm saying we should agendize our practices. But thank you so much for sharing your
Yes,
comments.
and I'll look forward to that discussion in November.
I would like
We'll
to
be
make
there.
a statement that's clear, perhaps for Ms. Jones' benefit. When I used the word we, I was referring to the committee, number one.
Understood.
And number two, whenever I speak, I'm only speaking on behalf of myself. I may sometimes use a plural, but I certainly don't assume that other board members agree with what I'm saying.
Thank you very much.
Hi, I'm Dr. Elizabeth Winkelman with the Director of Professional Affairs with the California Psychological Association. I wanted to, first of all, thank the board and the committee for the work that they've done on this issue. It's so important. We get calls about this all the time. And also for discussing the process of getting the public comment. I appreciate that. So before I talk about the substantive things, one other procedural thing I just wanted to suggest is, whenever possible, to give us the to give the public access to the actual documents in advance, because I think that really helps with being able to provide useful comments. and that once something is in a law or a regulation, the specific language really does matter, and we get, when people are trying to do the right thing and to comply with the law or the regulation or any other guidance from the board. So,
Good suggestion. I like that.
so I had a couple of specific comments. My main concern is about the interjurisdictional aspect that several people have mentioned. That's discussed in the section A. And I believe that the intent of the board is to simply talk about what is going to happen with the client who's physically located in California, or a client who's a resident of California but somewhere else at the time, and treatment of those people in those situations. However, I think that it's very important. There's two aspects of that I think are problematic. First of all of the other documentation that I've read about interjurisdictional practice, I think in most, if not all places, including the ASPPB PSI-PACT, talk about the physical location of the patient and not their residency. So I think it is potentially very confusing and problematic to talk about where the person is a resident and where are they the legal resident, and then what's the definition of legal, as opposed to where the patient is located. So the PSI-PACT, for example, and other guidance that I have read talks about when can you provide services to a patient that is physically located in another place. And this leads indirectly to my other main concern, which is I really think, and as other people have mentioned here, that interjurisdictional is a main issue here, in that at least half the questions that we get about this are about interjurisdictional practice, not just within the state. Both issues are important, and I think to come out on such an important issue with regulations, it should be more comprehensive to address both the in-state telepsychology practice and out-of-state telepsychology practice. And many of the same considerations apply in terms of, the security and confidentiality, and is telepractice appropriate for a particular patient and such. Much of it's very much the same, and the others, as has been mentioned by many other people here too, it will depend also on the other state's law. So I also think we need to be, we can't, and this is acknowledged in the current paragraph A, which is good, about the psychologist needs to be in compliance with the laws and the regulations of the other state where the patient is physically located when they receive the services. So those are my main those are my main comments that I would have concerns about. In addition, I wanted to say that Dr. Schaefer mentioned students, and right now you have licensee is permitted, and I think you might want to consider clarifying that a licensee or somebody under the supervision of a licensee, if that's what you intend. In addition, you talked about the health services and psychological services in telehealth. I do think that that's an important issue, and that as it's currently written, it would not really make sense to apply to IOs. For instance, you have the patient's client's diagnosis, symptoms, and medical psych history. An IO person may not have any diagnosis whatsoever. It doesn't really make sense, and I think that could also be fixed by modifying the language. For example, saying something like a licensee or supervisee is permitted to provide health care services. And I really don't think that the definition of health care services, or it might need to be crafted differently, I don't know, Ms. Mark can perhaps help to address that, to just make it clear that if you are applying it to other forms of psychology, it would have to be different, other types of services, or if it is healthcare services, I'm sure there's a way to draft it to make it clear that it's just for healthcare services. And my final concern, and I think this relates a little bit somewhat to what Dr. Schaefer is saying, people are looking to do the right thing here. They want guidance, they need guidance. Actually, sorry, I have two more comments. One is, but I'm hoping it's helpful because I really want this to move forward and I want it to work for psychologists, I want it to work for the clients, and I want it to help to provide clarity for everyone. Also, I'm a little bit concerned about the language in B2 and B3 that about any other issues. I think that in B2, any other issues the licensee can reasonably anticipate. I feel like that language is slightly problematic in that you could say including but not limited to risks and so forth, but any other issues, I can just imagine some very conscientious psychologists really tearing their hair out. Similarly with 3D, any benefits, risks, or constraints posed by the patient or the client's physical location. Again, if somebody's very conscientious, they're going to, are there any? So I think that, you can talk about the constraints that we know about and then say including but not limited to, or something such as that. So somebody who really in good faith wants to exactly do this right will know what to do. And related to that, and this is my final comment, is I just yesterday happened to find out about the Board of Behavioral Sciences standards of practice for telehealth that just went into effect on July 1st. And I believe that it would be worthwhile for the members of the board, and I know some of you are already familiar with them, but to take a look at them because they have standards of practice for telehealth that are very clear. They address the interjurisdictional issue as well as, I think, within the state. And it talks about some specific things that they want the practitioner to do, such as, ascertaining, the address of the present location at the beginning of each telehealth session, something like that. That a person who wants to comply with these regulations would know exactly what to do. But it's not as comprehensive as some of the issues that I appreciate that have been included here that are a bit more clinically focused and also relevant. But I think I think it's a reasonable, I think it would be a helpful document to look at. So thank you for the opportunity.
Please go ahead.
With your permission. There was one thing that you mentioned that I think is problematic relative to the actual law that allows us to pass these regulations, and that is that it does have to be a licensee to practice telehealth. So the actual legislation might need to be amended for purposes of allowing interns or postdoctoral students or whatever to be able to be covered by it. So that may be a separate issue. I think a lot of the things you bring up are very helpful and worthy of consideration. And we did take a look at the BBS regulations, and they may be worth taking a look at again in terms of moving forward with this to make sure that we're being more thorough in the way that we consider all these different factors. And I think the original issue that Dr. Horn brought up, which is, are we just talking about telehealth, or are we talking more generally about other types of psychological services, is certainly worthy of consideration. So despite my underlying feeling that I would like to get guidance to licensees earlier rather than later, I would suggest to the chair that perhaps that we should not put a rulemaking package forward at this point, and reconvene the committee and perhaps do some active outreach to some of the stakeholder groups in order to get their input in that process, so that we continue to encourage the culture, which I think Ms. Jones was speaking to, of transparency within the board.
Thank you. I am thankful that you said that, because I was about to suggest that we do the same, not knowing whether you would be agreeable. It looks to me like...
It's always a crapshoot.
Well, I guess I'd like to say two things. I think Ms. Jones' comments earlier about public input are important, and I've recognized within myself a couple of times thinking, gee, I'd like to talk with Dr. Winkelman about what she knows and bring it to the committee, but you weren't there and somehow it didn't happen that I called or whatever. So I'm aware internally that I've been interested in more input from people that are experts in the area. At the same time, and I don't mean this in a defensive way, but we've had public comment on this issue at several board meetings. It's not like the public has been excluded, but I do think we haven't had enough time to really get all of the input that would be helpful to us. And so that's the basis for my opinion or recommendation that we have a lengthier telepsych meeting that's noticed, and we get, I don't know whether it would take a half day, we can decide that and let people know, but, and craft, once again, a revised set that we bring forward. That's, I think, what I would recommend at this point.
It's my personal opinion that we would, I think, perhaps end up with the best regulations that we could possibly draft at this point within the limits of what the law allows us to do. I do think there is some question, Dr. Winkelman, as to whether we are able to address the question of interjurisdictional practice, what involves a California licensee and someone that's out of state, that is not that has no relationship to the state of California. But that could be part of the discussion that we have.
Which I think would be a rich discussion, because I was going to ask, and it occurred to me that it would take maybe more time than we have, for an example of how BBS's regulations would handle out-of-state where our proposed don't.
Well, if I could briefly, that's actually there actually is the very final, the next to last paragraph of the BBS regulation is just one sentence, and I think it addresses this very concisely. The interjurisdictional, it says a licensee or registrant in this state may provide telehealth services to clients located in another jurisdiction only if the California licensee or registrant meets the requirements to lawfully provide services in that jurisdiction, and delivery of services via telehealth is allowed by that jurisdiction. So they're very, I feel like they're very clear with that, and it's consistent with other things that I have read in terms of, you know, you really need to have, unless and until the PSY is in effect, that you should probably are going to need the license or temporary practice, permission to practice temporarily in another state to do that.
And I think being explicit in that sense would be helpful to the licensees.
May I just say,
Well,
that's all I'm saying. Thank you. Can we, and I think this is part of what you all said, if we can start the conversation, put it down so we can start the conversation, which will expand the concept and give it that level of globalness. I think that's what I'm hearing, and that's what I tried to say. Maybe I didn't say it so well, but
Ms.
thank you.
Jones,
You did, thank you.
Ms. Jones, you have a,
Yeah, Dr. Erickson, so I do support both yours and Dr. Phillips' recommendation to take it back, and it sounds to me like I would appreciate having the committee look at that notion that Dr. Schaefer mentioned and Dr. Winkelman mentioned, telepsychology, just the name, I think is an important conversation for the committee to look at. But also, as you mentioned in your final comments, Dr. Winkelman, about the PSY, we were unable to have our discussion this morning because we were not in quorum, and I do think that that might be a place where we can then pick up that conversation again as we look at this issue. And so I would hope that those two things, I would think they might be useful as a part of the conversation for the committee to consider.
as a follow-up,
An appropriate subject for a future agenda? So that can go on the agenda list, please?
Well, and I would say the agenda for the committee perhaps to start the conversation, because it sounds so connected to interjurisdictional practice, that would be a good place to put it on there to be on your committee agenda, not a board meeting agenda.
So looking at PSY within the context of the committee and then bringing it back to the board?
Yeah, because that would be kind of, it sounds like that would be a good tie to that work, as we've heard from the three people that brought public comment, where we're talking about in-state and out-of-state as well.
as a add-on to that, I took a moment to thank Dr. Siegel. Siegel? Yes. Siegel. To thank him for his coming today and that I hoped and he said he would come anytime we want him to come back. So the thought occurs to me that it wouldn't be totally out of the question to invite him to come to our telepsychology committee meeting to help us work with this perhaps. But we'd have to look at whether it warrants the time to make such a request, whether it would be good use.
Could I just say something about that? I mean, he could also appear by, or participate by conference call. So,
Good idea. So maybe can I turn this back to you, Dr. Phillips? Are we done with the committee? Thank you, Dr. Winkelman.
Thank
Is
you.
there more public comment that feels, is there anyone, Dr. Schaefer?
Can I just say from here? I just would like to reiterate that when we say that only a licensee can do telehealth, we have APA sites throughout the state where interns have been for years and are there as we speak, doing telehealth on hotlines and phone therapy. So I think we have to really address it if it's going to be, if it's a legal issue and it's already being breached, then we need to let APA know when California's being breached. And we need to allow those sites or APA sites know they're breaching the law, because this is what telehealth is. It's not just video. It's not just, something with your thumbs. It's on the phone too.
May I ask, though, to clarify, are you suggesting that interns are providing psychological service without supervision?
No, they're on a telephone. Hi, you're calling a hotline, you're suicidal, I'm going to work with you, or you're in a drug state, I'm going to help you get help, whatever it is.
What,
You're calling a rape hotline, you're depressed. This goes on all the time. Dee Dee Hirsch, the health group.
but this
major
law
APA
is for
sites.
licensees only, and what she's saying is that even people under supervision, they're trainees, they may be psych assistants, they may be whatever, under supervision, they're providing these services also.
So this may ultimately require a statutory change as opposed to
And
something we could do within the context of regulation.
Exactly.
I was taking it a step beyond that, actually, forgetting the telepsychology part. This is the provision of psychological service that's unlicensed, whether it's on the phone or otherwise, if it's a helpline, and is that appropriate?
Well, no more
They're
than
being
doing
supervised.
psychotherapy face to
It's
face.
not inappropriate.
Psychotherapy is psychotherapy.
Without a license?
They're being supervised.
I understand what a psych assistant is, but I don't think the interns are psych assistants.
There's a person there with a licensure.
I don't think so.
There are interns and psychological assistants and registered psychologists in the state of California who are doing telehealth with, for instance, clients that have gone out of state for a few weeks. And this does pose, I think, a serious problem in terms of wanting to make sure that our registrants and our licensees know the limits of what's allowed vis-a-vis telehealth.
Yes.
So I think we've raised a really important issue here, one that we might want to ask CPA to take a look at also.
And I agree with your issue. I was looking at another one that might be raised that wasn't telepsych. Trying to look at it and wait for another.
If I could just one closing comment, and that is to go back to the regulations 2905, is that right? 2905? The statute, 2905. It clearly says, this kind of goes back to some of your earlier conversations about maybe the need for other discipline, looking at discipline and so forth. Telehealth is defined as a mode of delivery. And I think when we have future discussions about that, it would be important to kind of keep that in mind. It is simply a mode of delivery. It's not something different from the practice of psychology. So I look at what APA has done, for example, with their continuing education. There used to be a separate sort of requirement for doing independent study, or home study as it was called. Now it's like you deliver you have a program. The standards apply whether or not it's a face-to-face program or whether it's delivered via distance learning. So I think it's important to look carefully at that language and and remind ourselves that it is a mode of delivery. It's not some weird animal. It's just a different way of delivering the services that you are licensed to do, or that you are able to do under supervision, which is, I think, part of what Dr. Schaefer is
Yes.
bringing up.
And all I'm saying is that I think we were all, to some extent, caught unawares by the fact that this may possibly not be consistent with the statute that the legislature passed, which gives me grave concern,
I'm not sure that I understand why you think it's not consistent.
because it says the only people that can practice telehealth are licensees.
And, oh, you mean these regs?
No, the statute.
It's already in place, state law.
What's the number that says it has to be a licensee?
Well, I think the confusion is, for me, is that 2904.5 says a psychologist licensed is a healthcare provider pursuant to 2290.5. That may indicate that it has to be a licensee. We may be able to take a look at this general B&P code section that says a license equals a registration. However, I am a little bit concerned that 2290.5 says that a healthcare provider means a person licensed under this division, again, which you can look at as a registration, if it says a marriage and family therapist, intern or trainee, which to some extent says if it's an MFT trainee, why did they not include a psychological trainee? And there is some rules of psych. I'm sorry?
They didn't say, when they used the word intern and trainee, that was after they identified the licensed people, that was comma, and then they used the terms for trainees and interns. You're assuming it's attached to the last licensed person.
No, I'm not. What I'm saying is that there are certain rules of statutory construction, and if the legislature knew how to refer to an MFT intern or trainee, they knew how to refer to a psychological trainee, and yet didn't. So I think we can take a look at that. I also want to offer that with respect to a committee and how it is formed and how it meets, it's not an either or. I believe that you could have a two-person committee where notice is not required, but it does not prevent you from giving notice. It does not necessarily mean it will be the 10-day notice that is required, but it could certainly mean that if you realize that everyone's available next week, that notice could be sent out. So it's not an either or, if that helps at all, about saying we want to be able to react to people's schedules, yet we want to be inclusive. So just to be aware that there may be times you're getting a notice for a committee meeting that's less than a 10-day notice because it's not required to be noticed, but yet it will be.
In a way that we can attempt to encourage stakeholders to be included in that process. Because right now, obviously, we're dealing with a relatively, I would call it the dream team, but I would also call it the lean team.
I'm confused. I thought we were going to talk about this in November because I was pushed back to agendize it. So I really think we need to have a robust conversation about the committee and our intent. But thank you, Ms. Marks, for explaining that to us. But I do think we should have a fuller conversation. And I don't mean to stop the conversation, but I do, because I was shut down, to continue the conversation. And I think we should talk about it in a full or agendized item.
For planning purposes, it'll be helpful, though, for staff to know what direction the board pleases to plan the next committee, at least for purposes of this language, between now and the November meeting.
My suggestion would be that we do, that we not try to add a third committee member at this point, that we attempt to give adequate notice to stakeholders so that they will be able to participate. And then we'll address the broader question as the agenda item in November.
Excellent, I think that's fine, and we might want to, I guess we do already, but if we, assuming that we'll notice this, and we might have a list of things that we want to look at that would help organize for us and for the public those items as well as others that may come up that we want to sort out best we can.
So does that conclude your committee report for today?
Thank you, Dr. Phillips, it does.
I think we do need to take a restroom break, because I noticed that some people have either had to spontaneously.
Dr. Phillips.
Couldn't wait, you didn't want to wait.
Dr. Phillips, Dr. Phillips, before we just. Thank you very much, Dr. Harris. That was a really good report.
Well,
We really
thanks.
appreciate
Appreciate
it.
it.
And thank you for the question. See what your question did? Thank you.
This
so
will
much.
literally be a 5-minute break, so if you need to go to the bathroom, don't get caught in a chat, okay?
Just like the last report was a 5-minute report.
Okay, we are now going to go on to the licensing committee report. Ms. Johnson?
Hello, it's Karen Johnson, the licensing coordinator for the Board of Psychology. My report is just an update. There's no board action required. I do have a few things that I do want to bring to your attention. One is the continued processing of the applications. The licensing analysts do keep those timelines down to less than 2 weeks. Right now, we're in our real busy time. This is when we get the most of our applications, is right after internships are completed, graduates are looking for postdocs. And so this time, if you look at one of our, actually I have a graph attached about the applications received. It's for the full fiscal year, and you'll see that this really is the time. And even with that, the licensing analysts are able to keep their processing times down. So they work very, very hard. They work as a team, and I just wanted to give them some kudos to how they work to get this down. If someone's on vacation, they're always there to help that individual to keep their workload down and really work as a team to keep this processing time down.
And I also wanted to interject that we have licensing committee personnel that are carrying double duties that sometimes interfere with their abilities. So it's particularly remarkable that you're able to do this, given all the strains put on your personnel.
We do have some good news. We have a new staff person that will be starting on Monday. Her name is Stephanie Chung, and she will be the licensing manager over the licensing unit. She'll be real involved with policy and legislation. This will be very important once we get all the pathways and implementing that policy. I'll be working very closely with her. I'll be continuing doing a lot of my functions as the lead person in the licensing unit and working with the analysts. And also, we're very excited about her starting on Monday. The licensing registration data, this is something that's in the enforcement report, along with a lot of other data. I like to just pull that out of that report just to bring it to your attention. It's just good information to see how many licensed psychologists we have. And this is like a snapshot. So I took this data on August 3rd. So this is what the licensing population looked like at that moment. Our next issue that I really wanted to bring to your attention is the 72-month limitation for psychological assistance. We're coming up to the 6th year. This regulation took effect October 23rd of 2010. So that would limit anybody who is a psychological assistant to a 6-year term. And it's consecutive, so we wouldn't count any kind of break they may have. If they have a registration, it cancels, and they get another registration a few months later. So it is that cumulative time. We've been working very closely with the Breeze team to try to figure out each individual person's time. And we've had a few hurdles in that because there's been a lot of variables that has happened during that period of time. Back in August of 2009, we went from an expiration date of January 31st for all psych assistants to a full year. So we had that issue. We also had an issue of going to Breeze in October of 2013. We've come to the realization that a lot of the data that was in our legacy, our CAS system that we had prior to 2013 was not really speaking to the new Breeze system. So the Breeze team was having some technical difficulties, you could say, barriers in trying to pull the data and getting an exact start date for a lot of these individuals who had registrations prior to the implementation of that regulation back in 2010. So we came up with a solution that we thought would benefit everybody, and it would allow us to be fair straight across, is having what they call a genesis date, a one date start date for everybody, and that would be October 23rd of 2011. What that would do is would capture anybody that would be have different dates throughout that year, because what it did was in the regulations, your start date would be your first renewal date after 2010. So you could have somebody every single day having a start date through 2011. So we thought if we started this date 10/23/11, we've captured all of those individuals. We have this start date moving forward. It's just a one-time thing for those individuals that had those prior registrations. Worst case scenario, it's giving some people an extra year or 6 months or 3 months. But it's a fair way to start. That's the way the Breeze team is able to implement the changes. There's a lot of things we need to do. It's like hold registrations, make it where someone couldn't get a new registration if they're reaching that 6-year term. So they needed to be able to implement those things into Breeze, and just found it impossible to do with all these different start dates for different individuals. And so that was a big change. We've already sent out letters to about 160 or so individuals who had registrations that began prior to, giving them their date. We're going to go ahead and contact them again and let them know of this and from this change and how we're calculating their time. So we'll be sending that out very shortly. I'll be contacting any individuals who've requested extensions of time. I'll be contacting them myself and explaining what has happened and what their new start date will be, and or when their termination date will be,
So in other words, we've given them the benefit of the doubt.
basically.
Yeah. Thank you.
To make it fair for everyone, to make it possible to move forward. And the Breeze team, Lanny Schneider, they've worked very, very hard to try to get this to work, and we just found it just to be impossible. So this was the solution, and unfortunately, unfortunately, we weren't able to go with Plan A, doing it exactly to the regulation. But I think this Plan B is going to work for everybody.
I think it's a really fair way to do it, you know. And like you said, at the most, it gives a year extra, depending on when people's
It's a
initial
handful.
start date was, but then from here on out.
Moving forward,
we're
it's
fine.
just a one-time. Pathways, we are still, licensing committee is still reviewing, getting close to being finished. Hopefully we'll be finished with the review of the regulations at our meeting on September 19th. And after that meeting, there'll be another licensing committee meeting, and we'll be inviting the stakeholders at that meeting, and it'll be facilitated by the DCA Solid to get all stakeholder comments on the proposed or recommended amendments and changes. So hopefully we'll have that probably after the November meeting, if we are able to finish up with the review in September. And then we have the pending regulation changes to 1387 and 1387.1. Hopefully that will be effective January 1st. We will be putting all the information on our website once we get that signed and in place. There's going to be that change to how we receive the documents. This will allow the supervisors and directors of training to give the documents, the verification of experience form and the supervision agreement form, to the trainee in a sealed envelope that's signed, and then they can submit that with their application. I think this really will benefit the trainees. We get so many phone calls from trainees saying, did my supervisor send that in? They said they sent it in. I just want to make sure you got it. If they have control of when that's mailed to us, I think it's going to relieve stress from them. Also, it keeps us from having to be this clearinghouse of documents for years for people who may never even apply for licensure. So we're very excited about that change. The other change that we're looking at is the removal of the pre-approval of the plan for psych assistants in private practice settings, and that's currently in section 1387B11. So that will be taken out of the regulations. And then we also wanted supervisors to provide feedback to their trainees, and so they'll need to add that to the plan, and that hasn't really been defined in the regulations currently, and we want that to be something that they're required to do.
Really quick, Karen, since Mr. Glassbeagle is sitting next to you, can you give the update of just where that's at in the process and then what the next step is?
Absolutely. That regulatory package was, I believe, reviewed by the Department of Consumer Affairs fully, and in the same breath. They don't tell us exactly when it goes to agency for review, but I did fill out a request for review for agency, so that's generally submitted and completed around the time it is going to agency. So my best guess, it is with the agency right now being reviewed, in which case after that it would come back to the Department of Consumer Affairs, be returned to the Board of Psychology, and we would then submit it to the Office of Administrative Law for review and hopefully approval.
And then, any questions?
So I'm sorry, but here's my question. Who is agency?
We are
If not the Department of Consumer Affairs.
the Department of Consumer Affairs. The department, we are under the Agency of Business, Consumer Services, and Housing.
Okay, thank you.
It encompasses multiple departments.
So it goes there first, then to DCA.
It is through DCA, and then it goes to agency. And I filled out a request for review from the agency specifically. So that was turned in last week or the week before to the Department of Consumer Affairs Legislative and Regulatory Division. They have a regulations analyst that manages the package while it's going through the department process, and then this person submits it directly to agency on our behalf. So I'm very confident that it is with agency pending review. They return it back to this person with the Department of Consumer Affairs, since that is the one that submitted it to them. This person will then email me and say, it's back, come get it. So I pick it up, and then if there's anything I have to make sure is signed, I do a review of it again, and then I turn it into the Office of Administrative Law.
Thank you.
Okay, then I have some, just some graphs and some statistics for your information, like our applications received. This is for the whole fiscal year, 15-16, which is July 1st through June 30th. Just how many applications we receive on a monthly basis. And again, you'll see that this time of year is very busy for us. Another one is just the number of current licensees we have, and psych assistants and registered psychologists, how many are inactive, how many are revoked, just some data that I thought you might be interested in receiving. And then our exam statistics for the full fiscal year. I passed out what is the annual report. This report is what's given to the department, and it's for the full fiscal year. And I did notice with the exam statistics, there's some discrepancy between my totals and what's on this report. So I'm going to be looking into that and meeting with the Breeze team. They take them from two different reports, and for some reason they're not matching. One is a monthly report that we do, and this is a total one report for the full fiscal year. So I'll try to figure out why there's discrepancies in the number of people who took the HIPAA and the complete, and the pass rates are a little bit off. So I'll find out what's going on with that and report back to you. But otherwise, that's the end of my report. I don't know if anybody has any questions.
Any questions, any public comment?
I just had a comment, but I have a comment.
Yes.
Oh, I just wanted to thank you very much, you all very much, and particularly putting this data in this form, which allows us to look at it from yet another perspective other than just enforcement. So this is wonderful. Thank you all.
Dr. Linda Crow?
Yes, Dr. Joe Linda Crow, CEO of the California Psychological Association. As I said earlier, I've been at CPA for a long time now. And so I have seen the ups and downs of the licensing renewal process. Some of you may have seen a story about the nursing delays. It was on Twitter and other places. I received a call from a reporter at Kaiser Health News asking me if I could comment for background on whether or not there were delays in the psychology licensing process. And I was very happy to talk to her about the huge progress that this board has made, and I just want to thank you. And I commented that both the staff and Ms. Sorik had made huge changes, that you had made changes in the processes, so I just wanted to say that. And thank you on behalf of CPA.
And thank you for your exceptional leadership in helping that to get done, Karen. Okay, we are on to agenda item number 24. Ms. Everhart.
Hello.
Very good name.
Whatever's fine. Ever
Everman.
You're confusing me. Okay, as usual, I've got the audits, and I've got the CE site and fines, and I've got renewal applications. So for the first attachment, those statistics are for the 2015 year. I'm still working on getting that year completed. So it's a snapshot of January through October, and what is not represented on that chart are my audits for November and December. I just sent out those requests as well. So for November, I'm auditing 75, December is 70. I've also, per Ms. Sorik's request, have been sending prior email notifications to let people know that they've been selected. And it's been really helpful because so many people don't receive their mail from at their address of record for whatever reason. And so that's been helping a lot with those complaints. I'm really satisfied with the results of that. So that's just a minor change, but it's actually had a pretty big impact on my processing. The next chart, you could see the total audits that have been actually completed or conducted. So 685 total. Out of that, 85 have failed, which I think is great considering it's not even 20% of the 600. So that's really good. The next chart, you could see reasons why people are failing, and the most popular would be that people are just short hours. And then the second largest would be that people, let's see, what was it? Short live hours. Some people aren't aware that they have to accrue live hours. I've had that happen before. So hopefully our audit process is getting that message across of our requirements. The next page, citations issued. These are from January 30th, 2016 to August 3rd, 2016, which is when I compiled this report. When I compiled this report, 3 were pending. Actually, 2 were only pending for abatement or compliance for the order in their cite and fine. And Dr. Phillips had asked me to speak to why these are pending abatements. One of them is in process. He's has been submitting them in piecemeal, so I'm getting those slowly but surely. And then I have one who has not responded, and a second notice was sent to that particular individual. So those are being taken care of. And then the last page, you'll see applications processed for both inactive and active license renewals, in addition to psychological assistant applications. And that's just for informational purposes only. And that is all.
Thank you.
You're welcome.
Oh, number 25 is the licensing committee report. Dr. Horn.
Before I would just like to thank Ms. Everhart for her report. Well done.
Thank you.
Okay, thank you, Dr. Phillips. Part A, review a checklist that supervisors may use to ensure compliance with the statutes and regulations. So I'm going to turn this over to Ms. Johnson, but I want to tell everybody where this comes from. We've been seeing with some regularity that people who have been applying for licensure or psych assistantships, etc., haven't had necessarily the things happening that they need to have happening that we have expected that supervisors would let them know. So we asked staff to come up with sort of a checklist for supervisors so that they can go down this checklist and make sure that they are advising their psych assistants, their trainees, whatever appropriately. So I'm going to turn it over to Ms. Johnson.
Okay, so we went through, and this is really to just aid the supervisors and the trainees. It just kind of gives them a look at all of the requirements for supervision. Just a good way to look at it. That might be easier to understand and have this checklist. The licensing committee has already reviewed this, had some minor modifications, and now presenting it to the full board to allow us to start using this document. We'd like to put this on our website. We're going to add it as a link on all of our emails and try to get it out there as much as possible, that this document is for their use. It's not a required document. It's just mostly to be helpful as we try to get it outreach and education and help in any way we can.
And you do face circumstances where people have because of their failure to omit to get the appropriate documentation, done 1,500 hours of postdoctoral work and not been able to get credit for
Yeah.
any of those hours.
And we're trying our hardest to get that education out there to keep that from happening, the denial of hours because of an omission on the part of the supervisor or the trainee. And if we can get this information out there in a way that's easy to understand, maybe that'll keep that from happening.
I'd just like to say about that too. We do see that as the supervisor's responsibility
It is the
primarily. Obviously, it's both the trainee has to be aware too, but we do see that as part of the supervisory responsibility, is that you're aware of the requirements for your trainee. And so just, that's why we got this.
I believe this will require action. Board action. So, do you have any questions?
Yeah, so go ahead.
Or do we want to do it at the end or do it individual?
Well, maybe we'll just do it individually. We would like the board to approve this so that we can put it on the website. We can send this out to supervisors, to training situations, training programs, and attach it to emails as well.
So I would move that we approve the supervision checklist.
Second that.
So any discussion from the board about this checklist? Ms. Marks, did you have something you wanted to say?
I would just ask if the board does want to approve this, that is with making some grammatical corrections and making some of the language consistent where it refers to either denial of hours or denial of experience, just making those things consistent. The only question I had, and I'm not nearly as familiar with the regs as the staff, so hopefully you can help me. On page, I guess it's the second page, and I guess I would recommend you actually number them and continue the headings across the top. It's the 1, 2, 3, the fourth row down where it says the primary supervisor is employed or on contract of the same agency with a trainee, but unless the primary supervisor is employing a registered psych assistant in a private practice. Because I assume that then it's assumed. So then is the second box over, which is a registered psych assistant, is that an NA?
Well, they could be registered to an agency and not in a private practice setting.
Oh, okay.
To a psychological corporation or medical
So the
corporation.
registered psych assistant is broader than, okay, that's what I was, thank you, that's what I was.
But thank
trying
you
to
for
check.
the recommendation to number it and have the headings on there. I'll take care of that.
Yeah, that's.
So I'd like to modify the motion to, the formatting process as well as, you raise an issue, Ms. Marks, or raise a question in my mind, that we just do a double check to make sure all of the the citations are correct and that everything is done with the grammatical issues as well.
Are you suggesting that be delegated to the executive officer and staff?
And to legal counsel where appropriate, I suppose. So that would be the amendment to my motion.
Thank you.
Is there a second? Okay. All right, is there any more board discussion about this motion? Any public comment about this motion? Okay, seeing none. Okay. Mr. Glass-Steagall, thank you.
No problem. All right. Akwayu Badu?
Aye.
Erickson?
Aye.
Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Motion passes.
Thank you. Okay, next is agenda item B, 25B, and this is the pathways to licensure. And did I miss something?
The flow chart?
The flow chart, yeah.
Oh, that's
Yeah. right, that's where I am. Okay.
Oh, yeah, I'm sorry.
It's okay. As we'll talk about later, we haven't really finished going through the pathways to licensing yet, but the licensing committee asked, and I believe it was Ms. Jones who asked staff to come up with a flow chart. Was it Dr. Phillips? Dr. Phillips who asked?
Flow chart.
Okay. Asked staff to come up with a flow chart so we could see the pathways, basically, because some of us are that kind of learner and that kind of understander. We integrate knowledge in that way. And so that's what they've done. This is what they came up, and it shows, again, this is something that we're going to want. If it's approved, we want it to go on our website for information for people, and also our plan, if it's approved, is to have it attached to people's applications for licensure as well, so that they can see, and again, make sure that they've gone through all the steps. But I'm going to turn it over to you, Ms. Johnson, if I...
Well, it's just a visual aid because some people, it's easier for them to look at a chart to really visualize the pathways. The regulations and statutes are kind of all over the place in our booklet. This just condenses it down into a flow chart that they can look at and see what the pathways are. And it's just a helpful tool for people to just maneuver through our requirements and the different ways they can accrue hours and all that. So just it's helpful.
Is it the intention that we start using the flow chart now, or do we want to wait till we're done with the pathways to licensure process before we finalize the flow chart?
I don't believe that the pathways is really going to change the flow chart. In a way, it can be a fluid document that may be amended, but I think if we want to get that out now, just to be helpful, and as things change in pathways, we'll update it.
This isn't going to go into regulation or anything. That's not what
It's
we're...
yeah.
Right,
Yeah.
right. It's currently accurate.
It's currently
Yeah.
accurate.
And it's very useful, I like it.
So is any more board discussion about that? Would somebody like to maybe move that we accept it and then, or?
I so
Don't
move
have
that we
public
accept
comment.
the flow chart, the pathways to licensure flow chart.
Okay, thank you. Is there any public comment on this document? Any more board?
Second that
comment?
motion.
Okay, oh, sorry. All right, so it's been moved and seconded. So, and I see no public comment, so Mr. Glass-Steagall, would you?
Wait, I have one more thing, I'm sorry.
Okay.
I'm not sure who said it. I think it was a staff member, but someone had suggested adding a supervision or supervisor portal to the board's website as well, so they can have one location that they can just go right to and have all that information right there.
That's
So
right.
Throw that out there.
Can we,
Is that, that's updating our website?
I was just gonna ask, can we put that in the motion coupled with something about allow this to be a fluid document that could change? Could that be in the motion as well? I'm just asking.
It can be, it doesn't need to be because this isn't a regulation or
Right.
anything, so I think we can, I think we're gonna always wanna be updating it to
But
reflect.
if we just put it in there
what's
to make,
current.
to be safe?
Sure.
Well, I would prefer actually, if it's going to be a quote-unquote fluid document, that each time that changes are made in the flow chart be brought back to the board,
Exactly.
as opposed to it just being changed without us seeing it.
Well, I would assume that's gonna happen. So what are you saying? Does that change the motion at all?
I don't see it changing the motion, but I also feel like that whole notion about the portal and the website, I mean, when we have a more robust outreach and education committee, I think that's something that would be on their radar also, to ensure that our website is being one that is user-friendly and accessible with lots of
Right.
information.
That's definitely outreach and education. Yeah. So, we have a motion, we have it seconded, there's no more comment on it, I think. So now I'm gonna ask Mr. Glass-Steagall if you'll, yes?
May I clarify, is the motion just to accept the flow chart as written, or is it also to add a supervisor portal to the website? currently, or is that being removed to go to
It's
the
not
outreach?
That's to go to outreach and
supervisor
education.
portal.
So just the,
Okay,
That's-
just the flow chart.
Just the flow chart.
Yes.
Okay, thank you.
Yes,
And to
except
bring
the
back
flow
any
chart, we
changes.
haven't talked about adding a portal or anything like that, that's later. Okay, Mr. Glass-Steagall.
Roll call. Akwae Badu.
Aye.
Erickson.
Yes, I.
Horn.
Aye.
Jones.
Aye.
Phillips.
aye.
Motion passes.
Okay, 25C. And this has got an update to it. It's actually a one-sentence update, but let me talk about what happened here and what we've since learned from the licensing committee meeting and kind of, I think, what our recommendation is, but I just want to make sure about that. So, if y'all see this draft licensing committee delegation, this came before the licensing committee at our last meeting, hoping to delegate in order to shorten processing time for applicants for licensure, that the licensing committee could decide final action on requests for licensure for extensions to the 30 consecutive month requirement to accrue the 1,500 hours. And for extensions to the limit of for psych assistance for a cumulative 72 hours. And that the licensing committee would report back to the full board the results of their deliberations and let the board know about that. So in our discussion at the licensing committee meeting, Ms. Marks brought up that she didn't think the licensing committee could have that authority, and correct me if I'm wrong, she was going to check on this, because we would, this is something that we can make recommendations to the board, but this is something the full board needs to deliberate about. And if we gave that to the licensing committee, it might mean that we would lose confidentiality, and we've sort of summarized the discussion that we had in your materials. If we did this might remove some of the confidentiality in which we've talked about these things, because as a licensing committee, we discuss these issues in closed session. And even though the information that's redacted is brought to the full board, and we protect confidentiality, as much as we can, those discussions have not been part of an open session, but part of a closed session because of the nature of the discussions. So we asked Ms. Marks to check on that, and because if that were the case, I think that we wouldn't be able to hold these discussions in confidence or in a closed session, then that, if I'm remembering correctly, that the licensing committee would not want to do this, if I'm remembering this correctly. So we were going to ask Ms. Marks to check on that.
Well, my recollection is that we actually didn't make a recommendation to move forward with it, given the conversation. And so, I thought we had dropped the conversation, so I wasn't expecting this to come back to the full board, because we said that given the work, we weren't gonna go forward on it. So that was a different kind of.
Well, she didn't know the answer to that, and we said if that were true, we wouldn't want to go forward with this.
Well, we also talked about the fact about, I know that in the last sentence of the delegation, the lengthy wait, the question became, how much are we really saving? And if the committee meetings before the board meeting, we weren't saving a whole lot of time, so we weren't really impacting the wait. So I thought it was the matter of like the whole goal of what we were trying to achieve, as well as the issue of other things. I thought we didn't recommend to go forward, but that was my recollection.
My recollection is closer to Dr. Horn's in the sense that we were going to make it dependent on whether we could continue to protect the confidentiality of the information. If we couldn't do that, then it would serve no purpose, in which case, obviously, going through this procedure of us would be, but we wouldn't want to do it.
Right.
But we can all have conflicting.
But that
The truth
doesn't,
is
that
somewhere
doesn't
in
take
there
away,
somewhere.
because what you said is also the truth, and that can, also part of what we talked about, that's reflected in these notes here that y'all have, is that one of the things that we said is, well, we're not even sure this saves that much time. So for sure, if we weren't allowed to do this, then we didn't want this to come any further. So what I want to tell the board and public who's here is that Ms. Marks has since found out that her original concerns, or what she told us, are in fact accurate, that we can't do that without this having to be, without these discussions having to be fully open if we delegated this final authority to the licensing committee. So I just wanted to give that discussion, but and so we are not going to do anything with this. That was what we said. So we ultimately came to that.
We all ended up in the same place.
We ended up in the same place. So this is a report, basically.
On something
We
we're not
don't have
gonna
to
do.
move anything here,
Yeah.
but I just wanted to let y'all know, because we do have that in here, and that was part of what we talked about. So we want to protect the confidentiality of our potential licensees, or our licensees, and we also didn't think it saved that much time.
And I think the other part of that too is that, much like with enforcement cases, the whole board gets a chance to weigh in on.
Right.
I think that's the other part too, as I was thinking about after our meeting, that it's important that we as a full board make decisions. And so, and again, it wasn't saving us months, because if we have a meeting in a quarter, the longest it could be would be 2.5 months. And usually they're closer than that anyway in how we schedule.
Right. Okay, so that's just informational. I wanted to give everybody the benefit of all that. Okay, D, the new statutory language regarding coursework and suicide risk assessment and intervention. Basically, we have looked at this. We've asked the staff to come up with some recommendations based on how other one-time only CE courses about a particular topic are written, and we've asked them to come back to the licensing committee with a suggestion about that. So this is also just for informational purposes. They're in the process, and we'll bring it back for our next licensing committee meeting, September 19th. Okay, item E, which is pathways to licensure. We are still in the process of these pathways, taking a look at these pathways, every aspect that leads to licensure, and making sure everything's really clear and consistent. And again, this is coming back September 19th. We think we'll probably be finished at that meeting with these pathways. Fingers crossed, but we'll see. So that's also for informational purposes. Item F, this is the code of, this is for 1397 and changes to 1397. This particular part is about CPD, and we are still involved in the language, going over the language about this, and again, making sure every part is consistent, that it's clear, that licensees will know what's expected, that also staff understands what we're asking them to do. We're just trying to make sure all parts are working together well. Again, we're hoping that at the next licensing committee meeting, we may be through with this review as well. It's only one day, so.
I love your optimism.
We'll see. I don't know how many times I've been saying this, but next meeting.
But I do think that in addition to, as you're identifying this for informational purposes,
Yeah.
I think that it's written here somewhere, and I think you referred to it earlier, the next phase would be the stakeholder participation.
That's
So
right.
I feel like, that is something that will be, not just bringing it to the full board, we're gonna do the stakeholder part next. And
Right.
I know that we don't have timelines yet because we're still going through this first phase. But I
Right.
think that's really an exciting aspect of what the licensing committee is working on right now.
Absolutely, and, I want to say about that, and thanks, Ms. Jones. All along, we've had public participation in this process, and certainly Dr. Linda Crow has been there every step of the way, and we appreciate what she's brought and others have brought as well. I think this stakeholder meeting, we're hoping that this will also be a larger stakeholder participation than has been before. We're going to really try and reach out to larger parts of the community of licensed psychologists, other members of the public, et cetera. So we're hopeful about that. We'll get a much broader stakeholder participation as well.
And just to clarify, Ms. Johnson has compiled, I think, a fairly comprehensive list of potential stakeholder groups for that purpose.
Right. So.
And facilitated by Solid, so really trying to think about it, doing it not like a
Right.
regular board meeting, which is pretty interesting to see how that will, play out.
Right, this will be facilitated by Solid, and so that'll be really good. Okay, the last thing for the licensing committee report is a request for an extension to the limit of the 72 months to renew a psych assistant registration. And the information is in there. This is psych assistant being referred to as number 1. This person is actually requesting a 3 to 4 year extension to the 72 months. The licensing committee looked at this information from this person very carefully, but decided to deny this request. That's the committee's recommendation to the board.
And just to know that she's been a psychological assistant since 1994.
Right.
She's asking for an additional 4 or 5 years. It appears from the content in order to kind of fill out the rest of her
career. Yeah. And that's clearly, that was one of the reasons why we took a look at this psych assistant category to begin with. So anyway, that's our recommendation to the
And the decision is certainly not to denigrate the contribution that this particular person has made to mental health access in the area that she's been in.
That's
or
right.
the importance of the services she's given, but it is consistent with the board policy, as I understand it, that being a psychological assistant is not a terminal licensing position. It is a pathway on the way to licensure.
That's right. That's right. Okay. Yes. So can I have a motion?
Sure. I move that we deny this extension, request to extend beyond the 72 months.
Second.
Okay,
Second.
Okay, so is there any board discussion about this? Any further board discussion? Does the public comment on this? Do they have this information? I just don't know. Okay. Is there any public comment on this request? All right, then I'd like to ask Mr. Glass-Steagall to call the roll, please.
So just for clarity's sake, this is going to be let me know if I'm incorrect, a motion to accept the licensing committee's recommendation to deny. So it's a yes vote, which accepts the recommendation, which would reaffirm the licensing committee's recommendation of a denial. Correct?
Correct. Thank you. That is helpful.
Absolutely.
Yes. If you vote yes.
If you vote yes. Yeah, no, the motion was to deny it, so either you're voting yes or you might not be.
Yeah. Aquabadu.
No.
Erickson.
Okay.
She can vote. At least she wants to vote.
Erickson.
Okay,
Threw off my timing here. Yes.
Horn.
Yes.
Jones.
Aye.
Phillips.
Aye.
Motion fails.
Motion. Did you say carries or fails?
Carries.
Because we only have 5, you have to have all 5 vote aye.
No.
My apologies, motion carries.
Okay, so, thank you. That concludes the licensing committee's report.
We're getting there, folks. We're getting down to the end of the agenda. Okay. We are now on to item number 26, which is a use of social media presentation that is to be summarized by Ms. Sword.
Included in the meeting materials is a presentation that was given at the ASPBB media meeting. And this, I was looking at the opening slide about media landscape. This laid out in the practice of psychology the use of social media as a tool and the pros and cons of using social media and things to keep in mind in a regulatory landscape. So that information is included in your meeting materials, and if there's any questions, and Dr. Horn was at the presentation, so she may have some additional insight as to the presentation or content.
I do. Thank you. I just want to say I recently attended this meeting, ASPPB mid-year meeting. The entire meeting was about the use of social media and regulation, basically, and how the two intersect. And I found it to be extremely, extremely helpful and useful. And I just want to say, interestingly, there's one of the people who was quoted a lot in terms of kind of good policies and recommendations in education for social media use was a California psychologist in San Francisco, Kelly Combs. So I don't know if any of y'all know her or if anybody listening knows her, but she was, a lot of people talked about her work. So anyway, that said, I don't want to give too long of a thing about it. There are a lot of things that people should consider, and one of the things that I came away with thinking that would be very helpful is if, let me just give you an example, because I gave the good and the bad kind of as an overview. And one of the things one of the presenters showed was clips of psychologists behaving badly that were captured on social media. And so I'm just going to give you one example of something that was given. This wasn't a California psychologist, and this wasn't a psychologist, but this was an intern. And it's in the middle of her internship year in another state. She was very drunk and fighting outside on the street with somebody for a taxi cab. That was caught on social media, put all over, you know, like Facebook and all like this. And her internship essentially fired her, or, you know. So she's in the middle of her internship year, and this is what ended up happening, you know. So that said, I mean, there were a number of things like this that were shown, and it's just like, you know, things aren't necessarily private. But I thought that it would be really a great idea if we did something, something educational along these lines. I think this would be something great for our licensees, trainees, et cetera, trainers. And I'm wondering if maybe the Outreach and Education Committee couldn't take a look at this issue and think about some education or outreach that we could provide to our stakeholders about this.
And we are fortunate in California that we do have some particular ethics experts on the use of social media. So when the time becomes appropriate, I'd be happy to provide those names to the Outreach and Education Committee.
Great. Great. So, should I move that, or?
I think
I'd like to, let's put this on the Outreach and Education agenda.
Yeah, I think you just,
Okay.
they were over there jotting.
Thank you.
Okay. And that would be the end of that particular report. So we've now reached the President's report. We are mercifully close to letting you all go out into your weekend. I wanted to take note of the 2017 board meeting event calendar. It has changed slightly as originally planned. At present, we are going to have our February meeting as we typically do in the Sacramento area. That'll be February 9th and 10th. The board meeting in Los Angeles has mercifully been moved to June instead of September, given the temperature in Los Angeles in September. From June 15th to June 16th. The Bay Area meeting is planned for September 14th to 15th. There is one change to the calendar, and that is, we realized that the board meeting we set in San Diego would, oh, I'm sorry. Do you want me to start over? I can start over. Okay. Okay. So the only real change to this sheet, which is probably the most significant fact about it, is the board meeting that will be held in San Diego will not be the 9th and 10th. As it turns out, because of when a state holiday falls, there will be a state day off, and so we're not going to ask employees to work on a state day off. So it'll be on November 16th and 17th, as opposed to 9th and 10th. 2017, correct. It's in your package, and
It was a hand carry.
it was a hand carry. Sorry. Yeah.
And just,
Go ahead. Okay, I've been corrected quite appropriately that it is a national holiday. And it's Veterans Day, a particularly important holiday. And I do not want to in any way denigrate the people that have served in our armed forces.
Would you repeat that, the holiday?
Veterans Day,
Oh, not that part, that.
the importance.
No.
No, when the meeting is, oh, I'm sorry, November 16th and 17th. Yes. I'm sorry, I misunderstood you.
No, it's late in the evening.
Okay. I think we're moving on then to, what the heck is this? Oh, committee updates. Okay, for all of the remaining meetings? Okay, just so you know, in looking at the following page, the next licensing committee meeting is going to be September 19th of 2016. I'm not going to mention the professional association meetings that are coming up or the national organizational meetings that are coming up. There's an outreach and education committee meeting that is currently scheduled for October 21st. And the next board meeting will be November 17th and 18th in San Diego. So we hope to see many of you there in San Diego. Committee updates. As you know, we are working with a relatively lean board at this time. We do have a new board member joining us. Unfortunately, she was not able to join us for this meeting because she was only recently appointed to the board by the President Pro Tem of the Senate. But she will be with us next time, and that's Ms. Alita Burnell, who I gave a little bit of an introduction about yesterday. She's actively considering joining the Outreach and Education Committee, and Dr. Horn has also agreed to become a member of that committee. so that we do not leave Ms. Akwebadu on her own. She cannot be 3 people at once, at least not without a major trauma. In terms of the other committees, obviously, as we get more board appointees, there are going to be some changes in committee assignments and some reshuffling. And obviously, I will be speaking to board members to determine which, if any, particular committees they're interested in serving on or continuing to serve on, and in what capacity. And then finally, item number 27C, which is a review and consideration of a draft delegation guideline. It would be a change in board policy. And the reason this arises is because there are occasions when, between board meetings, when we would not even have sufficient time to notice a telephonic board meeting, there's some major shift in legislation that's going to impact the licensure law or some other significant aspect of the treatment of mental health consumers or other stakeholders of the board. And so these draft committee guidelines are, the board committees are advisory and may recommend actions to the board. The basic point of this whole thing is that if something should shift radically in between times that we would be able to adequately notice meetings, that committee chair, in consultation with the executive officer, would be able to develop a specific response to the issue that arose, and that would then be brought to the board president for discussion, and then reported back to the board, but it may not be reported back to the board with sufficient time in order to have a board vote. And this is only so that we can remain, now I'm really worried about my use of words, nimble on the ground as to things that are late changes in the game. So the action requested is that we review and approve the committee guidelines for inclusion in the Administrative Procedures Manual. Is there any board, well, actually, does anybody want to make, should we have a general discussion and then make a motion, or would anybody like to make a motion?
I'd like to have discussion first.
Discussion
for 1 second.
first, okay.
Because I will just say, so as I was going through the documents and looking at kind of the delegation of the other, and I'm looking at and talking to other other boards and stuff, I think, isn't there a provision that allows us to call a quick meeting within less than 10 days if it is related to a special impact, like legislation that would impact the safety of consumers?
Yes, the Open Meetings Act allows for what's called a special meeting, which still requires 48 hours notice. So I believe this is written in the event that you could not even meet the 48-hour notice of a special meeting or gain a quorum. You may have the 48 hours, but you couldn't gain a quorum within a specific time period.
So I guess I guess that is tough. And then I was just thinking, because I'm hearkening back, in looking at this and talking to some other folks I know on other boards, and then thinking about today in terms of being able to get feedback. I'm not quite sure, is this the best way? In terms of, in terms of enforcement, we all get that information and we've got to reply to that. And again, in this case, I don't know if it's the committee of the Policy and Advocacy Committee or the committee chair, or the committee chair in this case. So it would be me. I would trust me. But at some point, I don't want you all to trust me. Like, I shouldn't be talking on behalf of the full board, should we? So I think that's what I'm left with in terms of kind of our need to have this kind of policy, given the fact that I know that other people can do the special meetings, which I did not know that until recently.
Ms. Sork, would you like to specifically respond to the thought behind this particular draft change to the policy?
Sure. I think it was in light of, actually, Ms. Marks and I were talking earlier, and it may not necessarily just be a time constraint, but it may be quorum constraints. And this would just give us the ability to quickly act in case we weren't able to get a quorum of the board together And as we know in the last few weeks, it's been a challenge to work and get a meeting scheduled, which you all have your regular occupations on top of charitably volunteering your time for the Board of Psychology. So I think not just the time constraints, but the quorum constraints, and I was glad Ms. Marks brought that up this morning as a possible amendment to this draft. And it would really just be to solidify, you know, being able to write a letter if we needed to in consultation with the Policy and Advocacy Committee Chair and the Board President.
Yeah, and I will just say, we have had challenges getting meetings. That was for a full-day meeting. I think that we were able to pull together our teleconferences a little bit more quickly, and we are a little bit more nimble on the ground for that kind of activity, and it seems like if we were trying to respond quickly, it's a quick matter. So I just offer that up in terms of, I feel a little, I know we've talked about this as an addition to our journal at the last few Policy and Advocacy Committee meetings, in fact, and then I guess I felt a little bit more hesitancy, and particularly after our conversation today, about ensuring that we have an opportunity, because if we have a meeting, even if we have a teleconference, the public can be a part of that process, either in person, wherever it happens, or they can call the number. So I think I'm having a little readiness, a little bit, not hesitancy, in moving forward on it in this piece, at this point in time, because I just feel like we all have, and you're right, we all have jobs, but we also all are speaking together as one. Kind of like we made the recommendation that it shouldn't just be the board president making the recommendation for the executive officer to travel to an event. So I think today I'm feeling a little differently given our conversation over the last 2 days. So that's all I have to say.
Are there any further comments?
I'm taking in what you said, Ms. Jones, and I'm not sure how we're going to all vote on this, but I would like to see, if we do go ahead with this, that we take a look at those decisions on a periodic basis and see how it turned out, whether this authority is well placed or whether we should maybe consider pulling it back if we do it. I wouldn't want it to be forgotten and these things happen and we never hear about it.
Really quickly, also, I just wanted to say, and thank you, Mr. Glass-Steagall, for mentioning this. We have had a couple of bills this last session that the board has been involved in, and there are amendments made at 4 o'clock or 5 o'clock, and they're going to be heard the next day. In that case, we wouldn't be able to meet the 48-hour, and in those very limited cases, but they do happen in August time frame or even July, that we want the ability to be able to, if we need to testify, and if the position needs to change, if we were supportive amendments were made, we need to pull the amended part of it out and just be a straight support. Or if we were opposed unless amended, things get amended at 5 o'clock. The next morning, 9 o'clock, that bill's heard. Staff just needs to have the ability to be able to work with the board president and the committee chair to move on that and not lose an opportunity to have a voice in the process.
I do note that the final line of the draft committee guideline is that the board shall be notified of such action as soon as possible.
I saw that as soon as I finished speaking.
So I think that the board will be immediately apprised of whatever action has been taken. If we find that this is not being used in extraordinary circumstances or the board is in disagreement with the actions that are being taken, certainly I think at that point we would certainly want to revisit this draft committee guideline. I guess I have enough faith in my colleagues and in the staff that I do feel like we do need some capacity to act in a rapid fashion in emergency situations. But I understand the hesitancy that other people are experiencing.
So
I would just,
oh, sorry.
I would just like to, that's a good idea, I think, as well. And I do see the conflict because what we've already just said previously. However,
I do see that sometimes we need to move quickly. So, and what I just wanted to add to that, if we could put time constraints on it now, let's say for this year, and look at it, and then revisit this and put a particular time period on it, would that help?
Or could we agendize it for a year from today?
Yeah.
Or
Have
for
it be
the-
like a pilot
Yes.
guideline?
Okay.
Why not? That'd be-
Would people feel
that'd be a
more
good
comfortable
idea.
with it?
That's fine with me. I think what I wanted to say is that I don't want to completely impede us. I want this to be I only want to be used in extraordinary circumstances when we can't get a quorum together in 48 hours or da-da-da-da-da, or we have to act right now, just today, and, you know. So in that regard, I think I'm in favor of this, but I would like to make it a pilot, put a time limit on it, and just kind of see how it was used. That's not the same as saying the board shall be notified of such action.
How about a mini
Yeah.
sunset review in 12 months?
Well, I would say review at the next corresponding quarterly meeting of next year. Wouldn't necessarily be exactly 12 months, but it would be whatever that meeting would be around.
After the legislative session.
The August meeting next,
After the
yeah.
completion of the legislative session. I'm not using
So,
the
so I have a
microphone.
question. Has there been a case where we haven't been able to move, where this has impeded our ability? And two, I would just ask the question, maybe Ms. Marks, you'd know, do any other boards do this? Because in terms of the issue of the board responsibility and as a member to be responsible to cast a vote, is that an issue that other committees have adopted a delegation of this kind of power for decision-making?
I do know of one other board. I have not taken any kind of poll. I just happen to know because I worked on, quite some time ago, at least looked at some draft language for such policy. So that's the only one I'm aware of because I've not sort of checked in with the other boards.
You say you drafted it. Did they adopt it?
Yes, they did.
Okay. And has there been a case where we haven't been able to move and be effective? Because I get the feeling, much like when we discuss between board meetings, in fact, we continue to carry our message of the intent and spirit of the conversation and the vote behind what the board has done in its position. And I thought that we've been telling them we're going to take it back to the full board if we need to change the position or not. But I'm not aware of a situation where we have been impeded, or maybe I'm just not aware.
I think one of the things that's been helpful this year is that we've had more board meetings than we typically have. I want to say we've had, by the end of the year, we've had 6 board meetings. So timing-wise, between the May meeting and this meeting, which is a really busy time for session, it really hasn't been as much of an issue. We did have AB 1715. We were opposed unless amended. And then the amendments we requested were taken, so we removed our opposition from the bill, which didn't mean we were supportive, but it just meant we removed our opposition. So that was something that at night, I think the night before we got the amendments, I spoke with Ms. Jones and Dr. Phillips and said, we've asked for these amendments, the amendments have been made, we've been asked by the author's office in good faith if we can pull our opposition. And I think this, to me, would have given me a little bit of a comfort level, knowing that I, went through somewhat of a process. I felt like I had the implicit authority because of the board's vote of oppose unless amended, and the amendments were made, so it made sense to me, but I think this just codifies this in a procedure manual that just gives the support, so.
Thank you, Ms. Stark. And I do believe the reason we were able to do that, was that in the motion, we then gave that delegation for that motion. So that's also why we were operating in the right spirit. And I actually do think, though, and I know we talked about this, about scheduling meetings. Last year, we also did a teleconference in July. It sounds like that we did 5 meetings last year, that maybe that is something we kind of go by as creating that 2-hour teleconference. in our schedule, and if we need to cancel it, we cancel it. But I just feel like I just don't want us to impede in any way the public's ability to make a comment and be involved with it. So I would respect us to make our decision and vote on it how we will, but that would just be kind of my hesitancy. And I would like to just see, as we look at this, you know, if we do vote and approve it, it sounds like that 1 year time limited would be useful. And I think it might be also useful if maybe we could get a report back from Ms. Marks with her colleagues, how many other boards do this? Because I just don't think, I would wonder if other boards are making sure that they're not limiting that participation, so.
May I make a motion to?
Please do.
I move that we accept the draft committee guidelines for inclusion in the Administrative Procedures Manual as detailed under item 27C
For 1 year.
for 1 year.
As a
Can I,
pilot.
can I make a friendly amendment?
Yes.
And that would be that it would be through the third regularly scheduled quarterly board meeting
Yes, through
of
the
next year. That way we don't have to worry about when that year exactly runs out. But we'll then have it agendized for that meeting.
And it would be a pilot program. I think that's important.
Mr.
The
Glassman.
August meeting of next year.
It's
The
gonna be
September
it's gonna be the September meeting of next year, actually, so, just so.
Yes,
that
that's what
we're
I meant
clear
to
about
say,
that.
yeah.
Would you accept that amendment?
Yes.
You're gonna open it for discussion.
It hasn't been seconded.
Before it's.
I'll second.
Okay, any
Just wanna put
discussion?
pilot, oh,
I have a question about the language real
Yeah.
quick. Ms. Marks and I went over some of the language and noticed a couple possible amendments for you to consider. Where it says, however, the board may delegate, the suggestion was to change that to however the board hereby delegates instead of may. Something to consider. Also, the executive officer, and to point out that it's the Policy and Advocacy Committee Chair, because we are talking about draft legislative committee guidelines, which is another amendment, is to spell that out, that it's the legislative committee guidelines and not just committee guidelines. And then on the following line, only in the event that time constraints, to also add in or quorum, time or quorum constraints preclude board action. And then the last is safety or welfare as it pertains to the mission of the board. So just a few edits.
So, Ms. Stark, a question about those edits. When you add the or quorum constraints, does that imply that there will be an effort made to try to get the quorum in 48 hours?
It would just lay out that if that was a challenge, if it wasn't just a time constraint, but if it was a quorum constraint, if the board was ever in a position where it only had 4 members appointed or whatever the case is, that it would also give us the ability to continue to be part of the legislative process.
I get what the quorum means, but I'm saying, is that going to be operationally, or we're going to try to at least do the 48-hour special meeting in practice? I guess is what I'm asking in different.
So we have the ability to call a special meeting for legislative reasons through the Open Meetings Act with the 48 hours. So this committee guideline would only pertain to anything beyond that 48 hours, or if we were not able to have a quorum of the board.
Right, right, that's what I understand the intent to be, which is that you may have 72 hours between now and the time the board staff or executive officer needs to act. But if you can't get a quorum, so either you have less than 48 hours, or you can't get a quorum within that time in order to call a special meeting.
may I just say that the first attempt will always be to get a quorum. Is
Right.
that what I'm saying? Is
That's
that
my
what
question.
That's, I thought, okay. That's the first attempt. And then may I also say, I like the draft committee guidelines pilot something another, so we can know that we're going to revisit this in September again.
I think we did include that language.
We did.
We did include that language.
And I do like all of the suggested edits that you made, Ms. Sorry.
Yes.
Ms. Sorry, could you repeat the last edit that you had requested?
Where it says the public's health, safety, or welfare as adding the word "it" as it pertains to the mission of the board.
Thank you.
Then would you add policy and advocacy but at the next line below that as well? So you have it twice, because you have committee chair twice.
Mm-hmm.
Yeah, so where it says committee chair, it should say policy and advocacy, committee chair.
We have it up here, but I heard us say it up there, but not down there.
Oh,
That was my.
okay. One was the other side of me.
Well, it's gotta be, it was gonna be both places, right?
Yeah, it should be in both places.
So-
I agree.
Executive officer and the committee chair, and then I see here the executive officer or committee chair. Do we want both, always? I'm just asking.
Only one needs to talk to the board president, right?
I'm just,
That's just letting them.
okay.
After the committee chair and myself would convene, one of us would
Go to the
go to
president.
the board president to consult on whatever the decision or recommendation that was made.
Okay.
So it would be all three always involved,
Mhm.
but it would, whoever the messenger was to get it to the board president for final review.
Dr. Erickson, are you comfortable with all of these additional amendments to your original motion?
Yes, I am.
And is whoever seconded comfortable with those amendments?
I am.
Okay. Is there any further board discussion? Any public?
I guess I do, because I would just say here too, because back to the question I think Dr. Horn may have asked or said, in terms of the reason why we were doing that are three things: changes to the licensing law, previously adopted board policy, and safety, health, safety, and welfare. And I guess in the example that we talked about, would that have even qualified if we used this as the three kind of lens to look through? I don't know if it would have, because it was, oh, that's right, it was a sunset.
It was a licensure.
1715 would have been.
Okay,
It
gotcha.
would have
I just wanted to
impacted our
make sure,
licensing law.
in terms of if that's encompassing.
Good question. Any further discussion by the board? Any public comment? Mr. Glass-Steagall?
Aquibadu,
Yes. Aye.
Erickson,
Aye.
Horn,
Aye.
Jones,
Nay.
Phillips.
Aye.
Motion passes.
Okay. Now, I think the next thing I want to address is, are there any? Are there any recommendations for future agenda items for future board meetings? Note that the board may not discuss or take action on any matter raised during this public comment section, except to decide whether to place the matter on the agenda of a future meeting. So are there any suggestions of future agenda items, other than those that have already been discussed and recorded by board staff? Appearing that there are none, I think I am safe in adjourning the meeting. Am I forgetting anything?
Does Ms. Noonan tell us what the items are that we said that will be coming up?
It was a combination of Ms. Noonan and Mr. Glass.
Okay.
We should have it all.
Okay,
If you'd like,
I'm
we
just
can,
asking.
we can provide the list as well.
I'm just asking, yes. Thank
Yes,
you.
okay.
I thought that's what we did.
So from day, and forgive me, I wrote down action items in addition to agenda items, so I'm gonna try to skim through this as quickly as possible. So for one of the agenda items, we have provide a more general policy, or I'm sorry, provide a discussion on the general policy, DCA's general policy on scheduling the executive officer to attend meetings. We have, let's see, add agenda item 20, which is Hernandez's bill, to the next board meeting agenda. Let's see, discuss the two-person committee.
Changes to the minutes.
It's really about noticing all committee meetings. That's the bigger issue, right? It's not.
I think it's
Yeah. Okay.
Notice instruction.
Yeah. And can I just say something? It's not necessarily the executive officer attending. I think what we said, we want to bring up the issue about the board's attendance, didn't we, at meetings? Is that what you were talking about?
Yeah, well, yes, to kind of explain that they have to have a speaking role at the meeting if they can, or in order to
Exactly.
attend.
So
Yeah.
we want to have this discussion.
Right.
But it's, yeah, it's just
Any
about
representative.
a representative
Any
of the
representative
board.
of the
Yeah.
board would be,
Right.
would need to be speaking consistent with the policy of the board as decided by the board and with the policy of the Department of Consumer Affairs. That's my understanding.
Yeah, and we wanted to have a discussion about this.
Right.
Yes.
Yeah.
And I don't think it's not Hernandez's law necessarily, it's the loan repayment programs.
I'm sorry, I was talking about the bill, just the bill, Hernandez's bill.
But the bill's gonna go away because the session's gonna end and it's not moving forward, so it's loan repayment in
Okay.
general, I thought.
Yeah.
Okay, and then this is going to be for the Telepsychology Committee, but take a look at PsyPact and look at the restraints of what the committee has to consider in terms of reviewing PsyPact. I have invited Dr. Siegel to the telepsychology meeting and possibly hold a teleconference. At the Outreach and Education Committee, discuss the supervision portal and provide education outreach to the use of social media. And then review the pilot program in 1 year, but I specified the meeting that you would like to have that in the minutes, so.
Mr. Glassbeagle, did you have anything else on your list?
Maybe just a few additional things that Ms. Noonan probably already has. The changes that the board would like to see to the structure of the minutes, having the minutes in chronological.
Is that an agenda item?
No, but it's just action.
Okay, so I have more action items if you guys want me to provide those. I just did the agenda items.
Why don't you give us the action items too?
Okay, so I have the weekly tweets to talk about not filing complaints on social media. I have reschedule, I didn't get his name, but Jason has it. Dr. Belovich for the LA board meeting. And then I also have, let's see, I think that was it actually. Oh, and I'm sorry, one more. Ms. Jones, you had requested Ms. Marks to provide the list of boards that she knows uses the committee delegation, or not the committee delegation, sorry, what is it called?
I think that was just part of the final analysis. So next year, we would have a part of the report of how it went. It would be just a report back.
Okay, so you want that information to be provided with the analysis of the pilot
Yeah,
program?
so we can
Okay.
see where we are in the universe of things.
And then just one more item was that we were going to include the language of the approved disciplinary guidelines in the next board meeting materials.
Anything further, Mr. Glassbeagle?
No.
Okay.
I guess I do have one item that I would like to make as an agendized item, probably for the Q1 or Q2 meeting. I know it's going to come back through the strategic plan, but the issue about our consumer outreach, and just have that as an actual agendized item so that we can all take a look at that and have a discussion about that. And I think I had that Dr. Horn was going to do a newsletter article too. What was that? You were doing it, I can't remember.
I've got it written down, I just don't remember.
And I don't know if it'd be considered an action item or not, but we did want to also make use of the idea of better educating our licensees, registrants as to the appropriate use of social media.
Yeah, I have that on.
That goes in the community, I guess it would go in the community, outreach and education
Outreach and
community. Okay, thank you. I just wanted to make sure. So I am happy to say the meeting is now adjourned. Thank you all.
Thank you.
Thank you.